Okay, everybody. So please bear with us because it's a long training, but there's just so much information, especially for somebody that hasn't practiced in juvenile court, that we really believe is all of this is the basics. None of this is an advanced stuff, but it's like a necessary basic that you have to grasp in order to really have an idea of what's going on in court and practice, ethically, zealously, and with diligence. So I will introduce myself and then Samantha. I'm Alexandra Chahan. I'm a juvenile defender advocate. So I'm a resource attorney for juvenile defenders in the state. If you have any questions regarding your cases or systemic issues, challenges, anything, you can always call me, and if I don't have an answer, I will definitely find an expert for you. So I help people with anything from writing motions, finding resources, connecting with experts to again systemic changes, which I'm really passionate about. And I observe court and I travel across the state. So if you practice in juvenile court, I will see you in court sometime soon. And it's my pleasure to present with Samantha Luck.
So my name is Samantha Luck. As y'all know already, I actually work for the Human Affairs Commission now. I was a juvenile public defender in Lexington County for 3 years, and then went to Richland County for 2.5 years, and just recently, back in July, left the practice of juvenile defense to just do something else. But my passion, I will have to say, still remains with juvenile defense, which is why I'm here today. And I'm so appreciative of Alex for letting me train again with her, and for y'all listening to somebody who isn't actually in the practice of juvenile defense anymore. However, at the end of the presentation, my contact information will be available. And I'm always, Cable will tell you, I'm always happy, excited to and fired up about talking about juvenile defense and all the problems I have seen along the way. So, but hats off to y'all. If you do get a chance to practice in juvenile and family court, it's very different, y'all will find, than general sessions. It's a necessity. And so anyway, thank y'all for being here and for having an interest in defending the kids in our state.
Thank you, Samantha. And one more thing, we're both JTIP certified. So the Gulf Center, that used to be a National Juvenile Defender Center, is a national center for resources for youth representation. And they have specific training developed for trainers, and Samantha and I are trained in that. And you will see the interactive aspect of our training really comes from them. And we're grateful to have been trained by the experts. So let me just put a couple things and put it in perspective. Is like why it matters what we do and how we do it, because it's not just a matter of doing it, but it's the quality of our representation that matters. If you look here at the statistics, what comes to your mind? And please feel free to just unmute yourself. There's not too many people. I don't think there will be, it'll be too complicated. But if you can unmute yourself and look, just after looking, briefly at those numbers, does anything stick out for you as a shock, or perhaps you have expected those numbers to be that way, but something that perhaps shouldn't be the way it is? So, and reflections.
I wouldn't say it's very shocking, but it's very disproportionate through race and gender.
Yes, Jamie, absolutely. So it's definitely disproportionate. Unfortunately, South Carolina is the most disproportionate state in the United States as of recent statistics. So yes, in South Carolina, children of color, Black children, are definitely both referred, detained, and committed to DJJ extremely disproportionately to white children. And that's why we will emphasize along the way today, and hope you will this message will stay with you. But raising race and talking about racial disparities is extremely important in our practice, because it cannot just be for years, actually for years, or if not decades, and it has not been talked about, but we believe that that really matters and that needs to be brought up to public's attention and judges' attentions, and those issues need to be addressed. So we will mention it along the way. So we will start, the first part of our training is about ethical considerations in juvenile cases. So that's where you're gonna get your ethic credit. But also you will learn a couple things about due process, right to counsels, and specific rules of professional conduct that we believe are most pertinent to youth representation. And we'll talk about national juvenile defense standards again, which are the gold center standards right now. So yes, let's Samantha start with the activity.
Okay. First, before we move forward, I see someone else has joined us.
Stephen is the.
Oh, I'm sorry. No one else has joined us. Okay, so we're going to start with the fact pattern. Number one, at this point, have all of you already had a chance to read over it?
Yes.
Okay, great. So what we're going to do is, in talking about our ethical obligations, we're going to use that fact pattern to go over a couple of rules of professional conduct. So we will start with the first question. Have you violated any ethical rules by going out to find your client despite the father's instructions not to?
No.
Okay. And can you tell me why you think no?
Well, it's the child, the juvenile, that's charged with the crimes, and you're appointed to represent the juvenile, not the father. And it's the juvenile's decision how the case proceeds, not the father.
Correct. As you've indicated, no. I'm sure everyone had the same answer. So here we look at the case of Enright Galt. It's the 1967 case that talks about ethical considerations in juvenile cases and the rights, the youth's right to counsel. So Enright Galt says a youth requires the assistance of counsel to cope with problems of law, to make skilled inquiries into the facts, and to insist upon regularity of proceedings, and to ascertain whether he has a defense, and to prepare and submit it. Obviously, you know, your client can't make decisions on their own without being properly advised by you as their counsel. And so we have to remember what our obligation is to that client. And we'll get more into it as we go along in this section, but I'll keep stressing throughout this section how important it is to maintain what obligations you have and how those obligations are not relaxed at all just because you represent a youth client compared to an adult client. We're under the same obligations. Okay, so we're going to talk about, like I said, specifically a couple of different rules of professional conduct. First, we have Rule 1.14 that deals with clients with diminished capacity. So what this rule, I'm not going to read every rule to you. I know you guys can read it yourselves, but I just want to point out a few things that minority can be grounds for diminished capacity. Of course, that does not create definite grounds for diminished capacity. So children, even though they're children under the age of 18, they can still be just as capable of making decisions about their case and about their representation as an adult can. The other thing I want to point out from this rule is that a lawyer shall, as far as reasonably possible, maintain a normal lawyer-client, client-lawyer relationship. And so that's one of the other big takeaways from this, that you have to maintain a normal relationship with your client, and it should not falter or lessen just because, you know, your client is a child. So let's talk a little bit more in detail about what's normal, what's considered normal. Here we have comment 1 from Rule 1.14. and again, it just talks about the fact that the normal client-lawyer relationship is based on the assumption that the client, when properly advised and assisted, is capable of making decisions about important matters. And I've already talked about the second part, but again, just because they have diminished capacity doesn't mean they're not capable of making important decisions as long as they're properly advised. Okay, also here we have in the commentary to Rule 1.14, children as young as 5 and 6 years of age, and certainly those of 10 or 12, are regarded as having opinions that are entitled to weight in legal proceedings concerning their custody. So what the court, what they're saying here is that, again, what I've already been saying, just because they're children doesn't mean they can't make decisions. And here the commentary tells us that children have been regarded even as young as ages 5 or 6 to be capable of making decisions about who they live with, which parent they live with, as far as in custodial proceedings. So that was just something I wanted to reemphasize as far as, you know, diminished capacity and children's capabilities of still making important decisions about their case. And as I go along, feel free to jump in, or if you have any questions or just want to add any comments or anything. We're very informal, as you see, it's just a few of us. More people may come in, but just feel free to, we want it definitely to be as interactive as we can. We want y'all to get the most out of it. And in my experience, is always the more interactive we are, then I think the more you'll get from it, rather than just sitting here listening to me talk or Alex talk. The other point of commentary in Rule 1.14, the fact that a client suffers from a disability does not diminish the lawyer's obligation to treat the client with attention and respect. You'll certainly have a lot of clients, if you practice in family court, who will have some form of disability. You know, you'll encounter some clients, of course, that, you know, you find are, you know, you have concerns about competency. Are they even able to make decisions, and may lend itself to needing a competency evaluation. But the fact that a child has a disability does not in and of itself mean that they're not capable of making decisions, and certainly should not be treated any differently than any other client without a disability. The other point 3 under the commentary, Rule 1.14, very, very, very important. The lawyer must keep the client's interests foremost, and except for protective action authorized under paragraph B, must look to the client, not to family members, to make decisions on the client's behalf. If y'all haven't already dealt with it, you certainly will. One thing I always had to remind people is, you know, I've had people come up to me and say, "Oh, do you really think that's in your client's best interest?" And my response is, well, I don't represent my client's best interest. I represent my client's wishes. So it doesn't matter what I think or you think is in my client's best interest. That's not our obligation to our client. Obviously, the court has to do what they believe is in the best interest of the child. DJJ and the state will say, you know, that's what their job is as well. But we have a very different and unique role in representing children in juvenile court. And so that's very, very important to keep in mind. One thing I've always actually told parents with my initial call to them, especially if I, you know, sort of got some pushback from the get-go, I would always tell them, just as part of my introductory or my introduction or, you know, background gathering, is to explain to them that I may have different or ask the court for something different than what they want. And while I understand they're the parent, I have obligations to my client. And although that client is a child, because I've always gotten the question, well, they're a minor, they can't make decisions. Well, yeah, they can. And I have to protect myself as, you know, my obligation as a lawyer, and I have to do what's best for my client. So I'm certain y'all will have that conversation if you represent any child at any point. All right. So what are the obligations defense counsel has to clients? What is normal? We've already touched on some of this. Let's see. I know Alex already mentioned it earlier on. How many of you guys have heard of the National Juvenile Defense Standard? Okay, good. Well, here we have Rule 1.2, dealing with illicit and represent client stated interests as our obligation, as I've been already talking about. On the next slide, I think will be our mirror local rule. And the point of putting this up is that the national standard is the same for us locally. Counsel serves as the sole voice of the client's expressed interest, as I've already said. You are not an advocate for what the lawyer or others believe is in the client's best interest. I won't hammer it over and over again. I've already said it, but just wanted to point out that the national juvenile standard mirrors our local rules as far as our obligation. All right, expressed interest representation. This is our local rule 1.2. Okay, we have to abide by the client's decisions concerning the objectives of representation and shall consult with the client as to the means by which they are pursued. That can be tricky sometimes. I think I've had situations where, I've talked to clients, and I think this is probably where sometimes you'll see if there are concerns about a client's capacity or ability to really make decisions. And I don't think we talk about competency evaluations in detail, but I've gone through cases, not from the beginning. It seemed as though there was not a concern. And then further along I get in the case, the client's not able to make decisions. And even when, I try to advise them, it just became clear the more in depth we got in the case that they just weren't understanding and wasn't going to be able to assist me with adequately representing them. And so I would err on the side, if I ever had a question about competency, I always erred on the side of getting a competency evaluation, because I never wanted to have a case proceed to adjudication and then there's a competency issue that I've missed. So even though a lot of times you'll get comp evals and they'll come back, especially here, because the standard is so low that the child was deemed to be competent, don't feel like it's a waste of time. I mean, there are other considerations, of course, you'll need to think about. Is the client detained pending that competency evaluation? As long as my client was not detained, and of course, even if they were detained, if I had a true concern, I always got them evaluated. But if they were not detained and I had any question, I would err on the side of caution. And I'll tell you just a brief story. One that pops in my mind in Richland County. It was a 14-year-old charged at CSC. He was in DSS custody. And I sat down at the courthouse and talked to him, and he sounded intelligent, and he was using words that I was shocked that he knew. But he was 14. And as I've already pointed out, the fact that he's 14 doesn't mean that, he has any diminished capacity. But something as serious as a CSC charge, I was just on the fence. And so I got up and I went out and talked to one of my colleagues, and I, explained to her. And as soon as I said 14 and CSC, she was like, "Yep, I agree. I think you should just err on the side of caution." Sure enough, he was found incompetent. And I will never forget that, because I was so, beating myself up. Although I ultimately done the right thing and the case was dismissed, but I was like, oh my God, I could have very well missed that. And that would have been a terrible thing. But so again, bottom line is, if you ever are on the fence, err on the side of caution and get that competency evaluation done. All right. So going back, and we'll have a couple of questions as we continue to go through the rules, so that we can apply them to the scenario. So going back to the scenario with Charles, what if you'd been hired by Charles's father rather than having been appointed by the court? Have you now violated any ethical rule duties in talking to Charles over the father's objection? If Charles's father had hired you rather than you having been appointed, does that change your does that change Cable's answer that we
It
had not
wouldn't.
violated any rules?
It wouldn't change my position because the father just simply for paying the fee for the if it's a private attorney, that doesn't mean that unless the client consents, that you even have to involve the father in the meetings with the client. That's completely up to the client if they want to have the father present, but you can't have an individual enter a plea because the parent wants them to, not if it's not what the child wants.
Correct, absolutely correct. So of course, the answer, as you pointed out, is no. So even if the parent or someone else hires you to represent the child, your obligations, as you pointed out, and you all know, still remain with the client, not the person who pays the bill. All right. Next, we'll move to talking about conflicts of interest. Here we have Rule 1.8. A lawyer shall not accept compensation for a client for representing a client from anyone other than the client unless one, the client gives informed consent, obviously. Two, there's no interference with the lawyer's independence or professional judgment or with your lawyer-client relationship. And three, the information related to representation of a client is protected as required by Rule 1.6, which we'll talk about in just a few slides. So just because, let's say, a parent is paying you, your client still is the boss, is how I put it. All right, another question. Can you talk to Charles's aunt or his sister? What do you guys think? Anybody else have any thoughts?
I think you can, as long as Charles doesn't object.
Okay. Anyone else?
Well, he in the fact pattern he says that he insists that you not contact his aunt or his sister. So under those circumstances, you wouldn't be able to.
Right. So both of you correct. The answer is no. The answer is no, based strictly on the fact pattern. Sorry, I'm trying to find my place here. What happened to this?
You have
Okay. Based on the fact pattern, the answer is no. But as you also pointed out, Roshana, if Charles gives you permission, then of course you can. All right, so here we have Rule 1.6 talking about confidentiality. So Rule 1.6 says that a lawyer should not reveal information relating to the representation of a client unless, obviously, as y'all have pointed out, if the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. I'll talk a little bit more about the second part of that is authorized in order to carry out the representation. An example of that would be like, let's say you wanted to, you were considering getting the client evaluated. Or you wanted to talk to Alex to see if she had some suggestions on maybe an expert or someone who you could talk to sort of, again, about an evaluation. I think is an independent evaluation. Then obviously you would need to consult with that person to give them some information about the case scenario, what your concerns are, to see if that would be appropriate or necessary, or if it's something they can do to assist. And I would never, I never have gone to a client and asked them, I mean, I've explained to them, like, in in the times when I've had comp evals done, I've of course explained to them what the competency evaluation was meant for, you know, but there's been a case that I can think. I had an attempted murder case, and it was a bad case. I mean, it was just a terrible, terrible case, and I had nothing to work with, but just sort of digging deeper into, you know, talking with the client and getting background from her, I learned that she'd suffered a lot of abuse from her mom, from her mom's different boyfriends. I mean, it was tragic. And so I consulted Dr. Kleinfelter to talk about, you know, what do you think? Is there some type of evaluation? Do you think I should get a private evaluation done in this case because the state had moved for waiver? And Dr. Kleinfelter was actually very helpful and, you know, told me just based alone on what this little information you're telling me, it sounds like there's some serious trauma, underlying trauma. And just in short, the facts of the case was that she and an adult male co-defendant had set up a plan to sort of get back at this guy who had been making passes at her online. And they met up and he had allegedly tried to touch her. And so all of that came up. I mean, all of that began to connect with Dr. Kleinfelter. And she said, you know, this incident was not related directly to the victim in the case, right? This was all of this underlying trauma that had come up. And I forgot to mention, it was also a pending CSC against her father during this time. Like, she had been molested by several males and abused by males and abused by her mom as well. And so it was just a lot of underlying trauma. So the plan was, I ended up leaving the county before the case was resolved, but the plan was to potentially do a some type of trauma assessment and use that as mitigation to try to get a good deal for as good of a deal as I could. So that's one time, of course, when, you know, you have to give the information in order to get the help you need to help your client. So here you see 1.6, you may reveal information if you believe that it's necessary to prevent death or substantial bodily harm, of course, and to prevent the client from committing a crime or fraud resulting in substantial injury to the financial interest or property of another. But the key word in that is you may. So you're not obligated to reveal information, but you may. The other things to point out is that your duty of confidentiality does continue after the lawyer-client relationship actually ends. Right? All right, and I think this is the last question before Alex will take over. Charles's aunt and sister calls Charles's school in an effort to locate him and find out if he's okay. The school tells them that you visited the school to meet with Charles, and they give out your phone number. What do you say when the aunt calls and wants to know who you are and why have you been visiting her nephew at school? How would you guys handle that? Any thoughts?
Maybe tell them that they need to speak with Charles to find out.
Good answer. Keep your mouth shut. So yeah, I mean, of course, you have to say something. I mean, you can't just hang up the phone on them. But perfect answer. I literally can't think of a better. That's exactly what I would say. So perfect. Does anyone have any questions about any of that? Oh, I actually do have. I was going to say before I pass it on to Alex, but it's not time to pass it on to Alex yet. A few more slides. So here we have another question. Charles denies any abuse by his father and insists that he wants to live with him. Can you report the abuse to the child abuse hotline? This is a tricky one, I think, for some people.
No.
Why is that, Kimberly?
We are not mandated reporters, and unless Charles wants it, sorry, got chaos in my house right now. Unless Charles wants to make a report, we can't do that.
Absolutely not. Absolutely. So, and I see where I think it's time to move on. But yeah, so I'll stop talking so much, but that will definitely come up over and over and over again.
Okay. So since you want your CLEs, we need to keep track of you keeping track of what's happening here. So we'll do it by using the code words. So please make sure you take note that the code word 1.1 is Berkeley. You'll have a little survey at the end to put them all in. Okay, Berkeley. Okay. So let's keep on moving with the rules. This time we'll consider rule 4.1, truthfulness in statement to others. Of course, it also comes up in our fact pattern. As a lawyer representing a client, a child, that doesn't matter what age, you cannot make a false statement of material fact or law to a third person. And also, you should be disclosing some material facts that that could be used to avoid assisting a criminal or fraudulent act by a client unless it's prohibited by Rule 1.6. So how it applies in our case scenario. Can you or must you tell the court that Charles lied about his father being his legal guardian? How would you apply this rule? Do you think it's, so let's look back at the truthfulness in statement to others. You cannot make knowingly a false statement of material fact or law to a third person. But generally, there is no affirmative duty to inform opposing party of relevant facts of law. How would you apply this rule to our question and case scenario about Charles lying about father being his legal guardian?
Well, you wouldn't want to volunteer that information openly, but if I had something like that happen with me in court, my client told me that this person was a legal guardian, but it was found out through DJJ because they tried to get records and they that person couldn't sign the records. And so I was confronted with that about knowing that he wasn't, the person wasn't the legal guardian. And all as I said was that at that time, it was my understanding that that was a legal guardian, and then they moved on. But you can't openly say that, I wouldn't openly say that Charles lied about it. Right,
because that would not definitely look good, right, for our client to present him as a liar. So it's pretty much an open to interpretation. So there is no right or wrong answer here. Just like you were saying, Kimberly, there is a context for that. So you just have to navigate that to, again, you cannot misrepresent it, but there's a way of saying those things that can protect your client in a way. And similarly, when it comes to the candor to the tribunal, right? Because that's very important. As a lawyer, you shall not knowingly make a false statement of fact or law to the tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So again, it's a matter of what is a material fact, right? And to what extent you have to correct it. And part 3 of the rule says that offer evidence that a lawyer knows to be false. So you cannot offer evidence that the lawyer knows to be false if a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity. The lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. So you may come up with a situation where at the beginning your client's telling you one story of what happened, so to speak, and then things change. So you probably won't have too many situations where you have trials where your client wants to testify, but that is something that can come up during a trial when a client wants to testify, and you know that the client would be saying something that by now was not true. So you cannot misrepresent to the court. But if a client wants to testify and say whatever they want to say, obviously you cannot stop them from doing that. But I really don't see it happening way too much. We usually don't put our clients as witnesses because it's things can go really wrong when our clients are witnesses. They're vulnerable clients in that sense.
If I can jump in for 1 second, just back to the scenario. What you could also do is talk to Charles and about him, not telling the truth about who his guardian is. Talk to him and see, explain to him why it's important if we go ahead and just tell the truth. If he insists, no, you can't, then you can't. But that's one way to handle it. And I think a kid would, once you've advised them, most of the time they'll agree, okay, I understand. So that's another way to handle it.
Sure. So the rule 3.3 continues here. Again, it's a little bit of what I already said. A lawyer's knowledge that evidence is false can be inferred from circumstances, although a lawyer should resolve doubts about the veracity of testimony or other evidence in favor of the client. The lawyer cannot ignore obvious falsehood. So yes, you always have to be truthful, but again, there is a way to navigate everything so you do not put your client under the bus, pretty much, right? You have to be really protective about your client. And to continue this in criminal cases, because in other cases, a lawyer may refuse to offer evidence the lawyer reasonably believes is false. However, in criminal cases, must counsel against the client offer false information. This rule does not permit a lawyer to refuse to offer the testimony of such a client where the lawyer reasonably believes but does not know that the testimony will be false. Unless the lawyer knows the testimony will be false, the lawyer must not honor the client's decision to testify. So that's something that I've already alluded to before.
I have a question real quick.
Yeah, I was.
What if Charles's father in court told the judge that Charles resided with him?
What do y'all think? What's your answer based on what we covered to Cable's question? So now we have father lying, right? Any ideas? Kimberly, you've practiced a lot. Have you had this type of situation come up that the parent is misinforming the court about something?
Well, I have, but it was a different situation in which one of the custodial, I don't even know what she was. It was an ex-girlfriend. She claimed to be the mother and a custodial. She claimed that towards the court, but unfortunately we didn't find out until after the fact. And my client didn't really understand what it meant by legal custody because he was living there. So, but I would say that's up to it's nothing that we have to deal with. I haven't had to deal with it. The judge dealt with it. I mean, the other side dealt with it more. It's the father lying, not your client.
Exactly. Yes. Thank you. So again, it's the father lying. You're not responsible for what he says, and it's pretty much on him, right? Thank you, Kimberly. Excellent answer. Okay. So when we go back to Charles's case, Charles will have difficulty complying with conditions of release if he continues staying with his father. So you know that Charles loves and misses his aunt and sister and believe that it would be best for him to live there. What can you do about it?
I believe you could ask for a home study to be conducted and see if like DJJ and DSS and the state would all be in like the same recommendation that he could go live with his aunt and sister as long as they were a good home and would take care of him.
Okay, anybody else?
That would be good if that's what your client wanted, if you wanted to go there. But it's because if we believe that, that doesn't necessarily make what our client believes. We can talk to him about probably the best scenario for him, but if he doesn't want us to pursue that, then I don't think we can.
Right, right. So yes, it's a great idea, Jamie, because it's definitely something that I hopefully like DJJ would do it on their own, right? Or some other agency. But again, our role, back to what Samantha was saying, is representing express interest of a client. So you should have a very honest conversation with Charles, you know, and that's what we will kind of cover in the next couple slides. It's we are the client's lawyer, definitely working on his legal case. But just like in Regold case was saying, we're the counselor for many other things as well. And we oftentimes actually are the advisors, and we're like the guiding hand for the client. So we have to spend a lot of time with our client, developing relationship that they can trust us. And so in situations like this, that a client is saying something and has an opinion that we understand would be adverse to their interest, we cannot go against what they say. We just have to spend time advising them on the situation, right? So perhaps through our guidance and explanation of things and using all the other factors, this particular rule actually says, you know, we can focus on moral, economic, social, political factors. So just remember that as a lawyer, this is not just a legal case. Oftentimes you will feel like you are a social worker, like you're somebody that really advocates for holistically for everything else related to this child's life, and so feel you know, assured in that role that this is something that you should be doing, which is advising your client all the other factors. And obviously, since you're working with a child that could be quite young, we always have to understand that, you know, their capacity to understand is not appropriate, not fully developed. And we will talk about interviewing a client after the break. We'll go into many more details on what to do when it comes to talking with a child to assure that they understand this. But just make sure you know to use simple, direct sentences and visual aids, you know, things that will really help the child really get the grasp of what you're saying, so they will benefit from your advice. Okay, so let's go to the next question. Charles would benefit from counseling and therapy, right? It looks like it from case scenario, but he tells you that he doesn't want to go because his father will call him a bag again. Can you ask the court to order it?
I would say no, because Charles explicitly said that he didn't want to attend counseling.
Okay, so that's, thank you, Cable. That's correct. The thing is that it's so tempting, right? Because oftentimes the court, I mean, you will see in every case they put counseling there, but you can advise again, Charles, about the benefit of counseling, right? Because most likely it will be on his court order, and if he doesn't do it, he's gonna fail his probation. So you should spend substantive time actually with your client explaining how he would benefit from those services and how his engagement is important. May you investigate the case even though Charles has told you that you do not need to? What do you all think? It's a tricky one, right? Again, express interest, he told you do not investigate the case. Is this that simple, or there is some other rule that you think you would be?
I don't believe it's that simple, because you have a duty to represent your client and provide zealous representation and investigate the case. And
Okay.
If there's a plea offered or a recommendation made by the solicitor and DJJ and Charles wants to accept that, and you explain to him that you haven't had the opportunity to fully investigate the case, and he decides that he wants to go forward with a plea, under those circumstances, I would tell him that, that's his decision, and make sure he's clear that I haven't had the opportunity to fully investigate everything.
Excellent. Yes, Cable. So absolutely, you must investigate, just like Cable said. That there is an actually duty, and one of the juvenile defense standards states that as well. Counsel must conduct a prompt, thorough, and independent investigation of the facts and circumstances of the case. It's codified in our rules of professional conduct, Rule 1.3. A lawyer shall act with reasonable diligence and promptness in representing a client. So that's definitely what Cable has covered. We have the duty to investigate the case, and there were cases of PCR, not in South Carolina, in other states, that clients spent 13 hours on a case and that was found insufficient. So I understand. I know 13 hours on a case sounds a little too many for some of you when you have hundreds of them, but that's something to really pay attention to, because that's your basic duty, is to fully diligently investigate the case. So you investigate and you determine that there is a very clear Fourth Amendment violation in this case. What do you say when Charles tells you that his father told him to plead guilty? What do y'all think? I think Cable actually answered this question, right? Cable, you have definitely alluded to that. You have to advise Charles that he has a good chance of winning, assure him that you will zealously fight the charges if he directs you to do so. So again, we have a duty to inform the client about the case and the extent of investigation you've done, what you found out, and definitely about plea ramifications. And that's why you have to know all this information that we will be delivering today through the training, because you have to understand sentencing. You have to understand ramifications of sentencing. You have to understand the consequences of being on probation and how that all will translate, because you have to relate it all to your client. So they can make an informed decision. They think probation, when they're detained, and all they want to do is go home and get their cheeseburger and stuff, they will plead to anything. But they think, okay, probation is cool, what's the big deal? You know how many probations are violated because they put way too many requirements on those probationary orders for the kids, and the longer kids are on those probationary sentences, the more chances of them violating. So again, your client, especially if it's his first time in court, won't have an understanding of that, and you have to make sure you advise them properly. And again, it may be ineffective assistance of counsel if you do not provide a plea ramification explanation, and that's based on the Supreme Court case from Layford versus Cooper in 2012. Counsel's deficient performance in advising client to reject plea offer and go to trial was ineffective assistance of counsel. Remember that. And the same with NJDC standards. The ultimate decision, of course, whether to plead or not plead guilty is on the client, but counsel must conduct investigation, assess the strength of the case, and then explain to the client. Look at the last part of this standard. Counsel must explain to the client in developmentally appropriate language the strength, weaknesses of the prosecution's case, the benefits, consequences of accepting a plea, and any rights client may be forfeiting by pleading guilty. That cannot be done in 10 minutes, guys. That's just like it's quite an engagement, right? So your juvenile clients will be much more difficult than your adult client, because they just need more time to grasp all those concepts. So just bear it in mind. So if Charles refuses to talk to you about the Fourth Amendment issue, do you talk to the father and let the father decide how to proceed? What do you think? Charles is not talking to you about that.
No, you wouldn't discuss that. I mean, that wouldn't be the father's decision as far as how to proceed with the case. And if Charles doesn't want to listen to you, you have to at least make an effort to explain to him that it's a viable defense and see if you can get through to him, you know, and change his mind if possible. But you wouldn't have the father make the decision.
What do y'all think?
I agree.
You agree? So I agree as well. Although, you know, you may talk to the father. You don't have to, but you may talk to the father. We will talk more about the role of parents, and Samantha already alluded to this as well. We have to make them into our allies oftentimes when we don't even feel like talking to them, right? So there is a lot of navigation and skill involvement also in getting them on our side, so to speak, or on our client side. But you can possibly talk to the client, to the father here. But again, I would definitely start with what Cable suggested, was you know, advising Charles and talking to him about that. I would not rely on the father's advice to, you know, make any decisions when it comes to taking the plea and trial and things like this. But you can, in this circumstance, you may talk to the father. So we will start talking about the interviewing youth clients in a minute, but at this point, let's take just a few minutes break. It's 10:01. If we could meet back at 10:15, okay? We will restart with the topic of interviewing youth clients. So we will see you all soon.
Okay, if everyone wants to come back and turn your cameras back on, we'll get started on the next section on interviewing youth clients. Okay, we are moving into our section on interviewing youth clients. Along with some ethics, we'll continue to refer back to the ethics that we've gone over in the first section. All right, when you're interviewing youth clients, these are some of the things that you want to keep in mind as your goal. Building trust and rapport with your clients, of course, gathering personal information about the client, getting specifics about the incident, identifying any possible challenges, strategizing how to get the desired results for the clients. And then if you're raising race, consider what additional factors might come into play. Here we'll talk about some of the challenges in interviewing youth clients. We've already talked about it earlier on regarding cognitive differences, well, as far as our responsibility in representing clients who may have diminished capacity. So that's something, of course, we have to keep in mind. Immaturity, obviously stress. Being in court is stressful for anyone, but especially for kids. There's a lot of uncertainty. They don't know what's going on. They're afraid of the outcome. You know, they have the risk of being removed from the home, away from their parents, etc. So there's a lot of stress involved, and we will talk about that a little later on when we talk about language issues with our clients. Lack of knowledge and experience, mental health issues, lots and lots of mental health issues with the clients we face that we represent. Lack of trust, and then language barriers or differences. All right. The breakdown in language zone can lead to the clients feeling that he or she did not understand the court process and what was not understood in court. So obviously, like I said, you know, children have a different, they talk differently than we do. They use different language. We as lawyers obviously use a lot of legalese when we talk. So there's a lot of issues with the languages that we have to consider when we're representing our clients in court. And we'll continue to talk about them more in detail as we go along through the interview process. Okay, here we have a fun little terminology quiz. Here to the left, I'm gonna pull up some legal terms, and I want you guys to just unmute yourself and throw out any suggestions that you have that you could use for more plain language when you're talking with your youth clients. Adjudication, what's a word that perhaps we could use rather than adjudication? Because surely our clients will know what that means. How about verdict or finding of guilt or conviction? What about attorney-client privilege? What term could you use to explain to your clients what that means rather than using the words attorney-client privilege? Any thoughts, Cable?
Well, explain to them that anything that you discuss with them is private and it's not going to be disclosed to anyone else unless they give you permission.
Perfect.
And if it's beneficial to their case.
Perfect. Confidential, professional responsibility, ethics, all of that's covered in what you just said. Beyond a reasonable doubt. This one's a little trickier, but perhaps burden of proof. You still may have to break that down a little more for your clients, or explaining that the government sort of, it's their job to prove beyond a reasonable doubt or without any question that they've actually done what they've been accused of doing. What about disposition? That should be an easier one. What word could you use for your clients to explain to them what disposition means? How about sentencing or outcome? Those would be good terms. A lot of kids, they know this one, but evidence. What's a word you could use instead of using evidence if your client does not know what that is? Starts with a P, ends in an F.
What you can explain that there's testimony from witnesses, police officers, eyewitnesses that is evidence that can be used at trial. Any kind of physical evidence, photographs, video, those are things that would be introduced at trial.
Perfect, perfect, perfect. Then the last one we have on this screen is presumption of innocence. Sort of ties back in above burden of proof. Again, that still may require some further explanation for a child, but those are just some words we might want to consider using instead of the legal terminology to help make sure our clients are understanding what we're saying. So here we have another quiz. This one is dealing with slang, and I'll have to admit I didn't know most of these. So let's see. To smoke somebody. Does anyone know what that means? If your client says to smoke somebody?
Shoot somebody, kill somebody.
Yep, perfect. Clocked.
Punched.
Apparently caught is what they are saying.
But I'm sure it can be met.
Yeah, I've heard it actually used as punch or you clock somebody. Yeah. On the box. Ankle
phone?
bracelet.
No.
Oh, monitor. Ankle monitor. Maxing out. I hadn't heard of this one before. Has anyone heard of that?
No.
Apparently that means flipped out or acting crazy. Someone's maxing out. Run your stuff. I'm assuming y'all don't know as much as I don't know these. Oops, I don't know. All right, well, we're gonna just have to put them all up there then. So run your stuff means empty your pockets or give up your money. Then you have stick, pull, or fry, which means gone. 12 is police. Gas or loud, it's weed. And rat or snitch, of course, we know that one, tell them someone.
Yeah, if I just may say, it is just as important for you to understand their language as for them to understand your language. That's how you build rapport, right? When you're savvy, so to speak, in and really understand what they're saying. I oftentimes would, you know, when I looked at my client's social media, I would have to go back and I'm like, please explain it to me because it's, you know, all Greek. But eventually you're gonna pick up some of the terminology. But be curious about that. Obviously, you have to know what's in the statements and things like this in police reports. And oftentimes your clients will use slang as well, social media for sure. Really hard to decipher.
Right, and you of course want to avoid assuming that you know, if
Right.
so, you want to avoid assumptions. So just to be sure that you're fully informed, certainly ask, or do a little digging and research and find out what they're saying on the street. So here we are up to our second code word 1.2, Williamsburg. Code 1.2 is Williamsburg. Has everyone had a chance to get that down? Okay.
Yes.
All right. Next thing is that really important in interviewing clients is overcoming lack of trust. There's a couple of ways you can overcome lack of trust with your client. One is invest time early. Alex has talked about it just before the break, how, talking to our youth clients is going to take more time than, if we were talking with adults. You want to follow your client's lead and avoid interruptions. You got to spend some time listening to them to get what they're saying, obviously get their side of the story, and sort of let them lead, rather than you just sort of taking over, because then they'll begin to open up more if you're willing to listen to them. And then next, you want to find areas of commonality. That it's really interesting. I miss talking to kids. Just before I get into all the nitty gritty things, there might be something. There was one kid that was from the same place that I was from, and so we started talking about that, and so that really helps kids get more comfortable, and they see you as a person rather than as their lawyer, because a lot of obviously a lot of us are I think all of us here are, most of us, public defenders, and so they already think you work for the state, and you're not there to look out for them. And so building trust with your clients can really, really go a long way, and so that's really important. All right, so overcoming lack of trust. There are some different ways you want to do that. There are some common things that I think we as lawyers tend to do, and some things we can do differently. One, you want to use empathy. Of course, show that you empathize with your client, that you understand, that this situation is difficult for them, that they might be afraid of the outcome, etc. It validate their concerns, okay, and their fears. Invite the client to ask questions. So you don't have to be the one that just sits there and talks. You want to, of course, hear what they have to say. And again, like I said previously, them knowing that you're willing to listen to them, it really can help go a long way with building trust with your clients. And then it's okay to say, tell them that it's okay to say if they're uncomfortable answering a question. Most of the time, if it's something they're uncomfortable with, it's probably not going to make or break anything, but just be sure that they know, you're not there trying to force them to say things if it just really makes them uncomfortable. And then I think you'll learn some strategies as we go along through this section on how you can break down some of these barriers and make your clients feel more comfortable. Make sure your client does not feel like you're judging them. So, they're in a system, in a criminal justice system, where everybody else around them is judging them. And so the last thing you want is for them to feel like you're yet another target on them. They need to know that you're there for them. And so make sure they understand you're not judging them. I used to tell my clients, and I had one parent ask me, well, my client told me that the parent said something to him, and I followed up with her. But I used to always tell my clients, I don't care if you did it or you didn't do, if you did it, you could have killed somebody. I said, I'm not gonna I really don't care. I'm not going to represent you any less. And believe it or not, I really felt like that made my clients understand that I was there for them, to represent them. And one parent told her kid, well, I don't know why she would tell you that. And so I asked the parent, I had a good rapport with her, and my kid was charged with CSC. And I said, because I want him to know that I'm not here to judge him. And if he did it, that's not going to make me represent him any less, or not, I'm not going to put forth any less effort because he did it. And it was actually a CSC case that my client had denied for a whole year until I guess he just had to finally get comfortable when I got an investigator on it, and he admitted to the offense, and I was able to literally get him home on probation. So, and then the other thing, as far as, not judging your clients, make sure your client knows that you're there, like I said, to represent them, and it's not contingent on what they're, what they tell you they did or didn't do. All right. The other thing, I'm sure you guys have heard of this before, you want to ask journalistic questions. Okay, what does that mean? Well, you want to ask, open-ended questions, the who, what, when, and where. All right. You want to avoid, on the other hand, why or how, asking why this or how could you. Obviously, that's going to immediately have your client put up a defense, because it's coming across, like I just said a minute ago, very judgmental. And so you want to avoid those type questions and ask questions that's going to open the door for your clients to open up to you and talk to you. All right. So as far as like judgmental questions, and we're all guilty of it, so I'm not here throwing stones. I've done it myself. But here are some suggestions for you guys to use rather than the judgmental questions. Here are some ways to reword. So rather than asking why didn't you follow probation, or did you follow the rules of probation? Okay. Maybe you want to say, well, let's talk about probation. Okay. Maybe you want to say, let's talk about probation. What'd you have to do on probation? How'd that go? Why didn't you get a job? So what could you possibly say to your client, or what could you possibly ask them that would make it seem less judgmental, rather than why didn't you get a job? You were supposed to do that as part of probation.
You could maybe approach it like, hey, are you interested in a job, or is there kind of jobs that interest you that you'd like to do? Do you like to work in fast food, or you like to work with people? Kind of go with it at that angle.
Right. Great. Another thing you might want to say is, obviously a lot of kids have, like adults, have barriers to work. And so you might say, is there something that kept you from working? Maybe they don't have transportation. And that could be an issue. What about, rather than asking, have you been using drugs? How could you approach that differently? So obviously it's information we'll need to know. You'll definitely don't want to be surprised about that, but how could you find out, if your client's been using drugs, rather than just come out and asking them, have you been using drugs?
You could ask them if they're using like any kind of unhealthy coping mechanisms or things like that, that kind of bring it out without directly asking or feeling like they're being accused of doing something.
Yeah, that's actually a good idea. Right. I was thinking like, you could ask, what will the drug test show? But that's actually a good idea. One of the questions, I had like standard questions that of course I'd have to expound on based on the case, but one of my specific questions were, have you ever used any drugs or alcohol? If they say yes, then I would ask, what's the last time? And if I sort of sense they were hesitant and just sort of not telling me, and I'm like, oh, I need to know. We don't want any surprises. What if the judge orders a drug test? And so that's how I would get that information out of them. But that's also a very, very good suggestion. What about why did you fail to report to your PO? What could be a way to address that with your client that would seem less judgmental?
You could ask them, you could say, I understand that there was an issue regarding reporting to your PO. And can we talk about that? Can you explain what happened?
Right, exactly. That's what I was thinking. Tell me what happened with your probation appointments. We know, I mean, you'll see a lot of time, not a lot of times, I guess, but sometimes definitely, it's the parents didn't take them to appointments. And so, I mean, that's not your client's fault. They're kids. They can't drive most of the time. So yes, but that's a very good way to deal with that. All right. Here, let's talk a little more about overcoming lack of trust. Here, we want to talk about some things that you do and don't want to do. So you don't want to say, you can trust me. That just, I think that gives them you're sort of given too many assurances. I mean, it's like, that's the worst thing you can say to somebody, like, to get them to trust you. Oh, you can trust me. Well, instead show your client they can trust you. Don't just tell them that, right? Instead, you can explain to them that your role as their defense attorney, like I said, you're there as their advocate and to express what their interest is, not what someone else believes that their best interest is. Don't make a promise you can't keep. Instead, you want to make maybe a few easy promises that you can keep. For instance, you know, if I told a kid that I was coming to JDC or to Alvin Esplin to see them, then I had to make sure that I was there. If it was ever an issue where I couldn't get there, I always followed up with someone. Either I had a colleague who was going there, can you please check on my client, let them know I wasn't able to come again, or I would develop a good relationship with somebody at one of the, at the Alvin Esplin or JDC. Do you mind passing along, message to my client? So don't make promises that you can't keep. Obviously, things come up. Just make sure you follow up because you want your client to be able to trust you and that you'll stick to what you told them you'll do. You don't want to have others in the room during privileged conversations, but you do want to explain the confidentiality rule, the lawyer-client privilege. And I know, Cable, you've talked to me about this a couple of times. When I was in Lexington, I did things a little differently. I would never allow a parent in the room. I immediately had my paralegal bring back the client. I didn't even invite the parents back. And most of the time that worked. The clients didn't. I explained to them why I was meeting with them first. There were, of course, a few younger clients that wanted their parents to be back there, and then I would let them back. When I came in over at Richland, just because I realized I was, things got a little even crazier over here. I would just explain to the client and the parent before I started my meeting about the attorney-client privilege, and have the client make the decision whether or not they wanted their parent there. And of course, I talked about the implications of having the parent there during our conversations. And the way I normally got the parent to leave is by telling them, well, if we end up at a trial, you could be called as a witness to testify against your child. And so that they're like, oh, well, let me go then. But I did have clients a lot more times here in Richland tell me they wanted their client to leave, and their client, I never had anybody that didn't respect that. All right, listening skills. Like I said, it's more important to listen to your client than it is for you to talk. And I really like this slide. I'd never seen it until I did the training last year. It says the word listen contains the same letters as the word silent. Something that I'm sure a lot of people would say that I could practice a little more, but but that's very important. Like I said, when you're representing kids, you got to listen to them, listen to what their fears are, listen to what, their side of the story is. I made sure when I was going through, I always read incident reports word for word, as long as they weren't like pages and pages. told my clients, explain to them, I'm reading to you what this incident report says, and then I'm going to get your side of the story because I don't believe what I read. I don't just believe what I read in incident reports. And I think they always appreciated that. And I made sure I was just informing them of what they were, what were they being accused of in the circumstances, but made sure they knew that I wasn't accusing them of having done it just because law enforcement said they did it. All right, and of course we've talked about this regarding our ethical rules and when dealing with children with or clients with diminished capacity, accommodate limited cognitive capacity. It takes children a longer time, obviously, to process information. So you've got to be patient. You've got to take the time with them. You've got to provide that zealous representation. Make sure you explain to them. Remember, we talked about the professional rule of conduct regarding advising our client. We talked about, the case of In re Galt. So, I mean, all of that goes into dealing with or fully representing your client and advising them when they have limited cognitive capacity. Oh, let me go back a minute. Yeah, I wanted to go a little more in detail just to give you guys some tips on some more things you could do. We've already talked about avoiding legal S. We've talked about terminology, more plain language terms that we can use. You want to avoid long questions with a lot of information and options. You want to use visual aids if those are available, even if it means you're creating charts and things of that nature. One thing I always did is when I was going through, because of course y'all know, there's a lot of information you're giving to a client about the possible outcomes. And even if I have recommendations as to probation from everyone, of course, we know that one, the judge is going to go through, the judge can do what he or she wants. The judge is going to bring up the fact that they can send them to DJJ until age 22. So I went through all of the options, and I realized early on that, gosh, this is a lot for this kid. They're just sitting there looking at me, and I'm just sprouting out all this information. So what I started doing is I would write it out, and I thought about just sort of writing it out and then just keep making copies. But then I realized if I write it out as I'm talking about it, it laid it out for the kid. So I do option 1, probation, and I put up until 21. I put MEC, I'd even put, I'm like, this is not likely to, I don't think this is likely to happen in this case, but I'm letting you know that this is an option the judge has. I put CE, explain the community evaluation. And then I tell them, if you get a CE, you get an MEC evaluation, then we've got to come back to court. This is what's going to happen next. And then once I got the recommendations, or if I already had the recommendations, I'm sorry, at that point, I would ask the kid, okay, so which one of these do you want? Do you want me to ask for 1, 2, or 3? And which one of these is DJJ recommending? I made sure that they understood. But again, that's a lot of information to process for anyone who's not familiar with the system, more or less a kid. So me writing it out, I felt like really did help a lot. The other thing you want to do is use the T-funnel method. So first, you want to begin with open-ended questions and then follow up with more narrow questions. By doing this, you're, one, showing the client that you're interested. 2, you're determining what's important, what the client remembers, and you're avoiding suggesting answers to your clients. Your clients look at you, you're an adult, they're a kid, you're their lawyer, you must know everything. And so they're going to say whatever they think you want to hear, right? But you want to, start with open-ended questions. So, and then narrow things down from there. So you don't feel like you're putting words in their mouth. Sometimes when I have felt like I've sort of just talked a little too much and I felt like, oops, I would have them sort of relay back to me you know, what it is. I've told them to be sure they understood, and ask them, you know, well, is that what you would do? My clients would ask me a lot if I'd say, oh, well, what do you want to do? You want to plead guilty or not guilty? Well, what would you do? I'll do whatever you say. I said, no, no, no. I'm your lawyer. You have to make this decision. And even if, and I would never, 100% of the time, I would never tell my client if I would do what they have decided to do until they told me what they decided to do. Okay. So, but you will get the question. I promise you will if you represent you clients. We also want to be careful not to misread clients' body language. We've talked already about different language styles. But the other reason I want to go back or want to delve into this a little more is because you want to identify any behaviors and the reasons, possible reasons for those underlying behaviors. And I think Alex is going to get into that next. So, but I just want to introduce y'all to this. So you want to, let's say a child is like quiet. They're not talking much. You're asking them questions. They're just sitting there looking at you. Well, that might, I've seen judges read that as disrespect. Well, or maybe they're just really scared, or they're just quiet. I mean, that sounds like much more of a reasonable reasonable reason to me than just being disrespectful. Again, kids communicate very differently than we do. I actually had a kid, I think this happened twice, but I had a judge in one case call my client out, and I jumped immediately. I'm like, Your Honor, this is how he's been with me, and it's because he's nervous. The kid kept like laughing or smiling, and the judge thought, oh, you think this is funny? No, they're nervous. Like, chill out. I just remember that, and it was in Lexington County. It's just those judges were really tough out there, and so yeah. So just keep that in mind, and try to understand, like I said, the possible sources of this behavior. Again, this is stressful, very stressful for your client. It's scary for them, a lot of uncertainty, and so that's why you will see some of the behaviors that you see. Or that I guess we would consider maybe behaviors, and they're not really behaviors. It's just the way the kid communicates. So Alex is gonna take it from there for now and talk a little more about what's underneath the behavior and sort of how we can address those issues.
So I would also say, when you recognize a behavior that is an indicator perhaps of stress, nervousness, before a hearing, address that with the judge. Give the judge a warning. Like, I had a disabled client who was combing his hair. Like, that was his coping mechanism, right? Definitely not acceptable in court and by many judges. But by approaching the judge and explaining, hey, this is the child with disability, that's his coping mechanism, perhaps you may find a judge who would understand that, and that would definitely help your client behave, so to speak, in court, and the judge not taking things personally, which unfortunately happens. So like Samantha was saying, looking what's underneath the behavior is really important, because we sometimes also will take things personally, right? If you're meeting with a client, you're working on building trust and rapport, all the good stuff, and they act up, they are angry, they slouch and they don't want to engage, or they roll their eyes, at some point you'll be like, okay, my client is disrespectful towards me, right? But it's very important to actually never take things personally, and really go and see what's underneath. There is a great article that we will share in resources with you, and it's titled "Everything We See Hides Another Thing," and that will really provide you some more understanding of what may be happening for a client. Children can be embarrassed, right? They're in court, they're in shackles. Oftentimes they are in situations that it's really embarrassing for them, shameful. They oftentimes obviously have been traumatized before. They could be confused. They they know they have failed, right? In so many ways, they have disappointed parents. They feel like they're disappointing you as an attorney. So they may be acting in ways that, again, we may perceive one way, but it's really important to understand the underlying reason for what it is. So you have ultimately more compassion and empathy, and you can show that to your client. So we talked about language and language barriers and breakdowns, and had some quizzes and exercises about that. So all of this to say is that words really matter. And this is another exercise that will take us to another layer to try to be mindful about words we use when we refer to our youth, to clients that you represent, and perhaps their whole circumstances, situations they live in, because the words you will use about your client to him or her one-on-one or in court matter greatly, and that impacts how a child feels about him or herself, right? Ultimately, you are the person in authority, and what they hear about themselves in court can tremendously impact their self-esteem. And as you probably have noticed, in court, everybody uses language that's not most encouraging, and for a client it's to the contrary. So we'll now work on those words and how we can change our own vocabulary, because it really matters. Even if everybody in court talks about a kid as a juvenile, that's a criminal breaking the law, if you find vocabulary that's more respectful and elevating a client and you use it in the setting of a courtroom, it's gonna impact the child greatly, because they will understand you are their advocate, and they'll actually feel better about themselves, but also about the relationship they have with you. So let's say the prosecutor talks about your client as an aggressive kid. How would you reframe it and use a language that actually affirms and humanizes your client? What other words could you use to say the same thing, but with much more respect? I'll give you an example. So you can say that your client is assertive, right, about your opinions. Depends what the aggressiveness is about. Is it a violent behavior, or is it like aggressive in some expression? But you can definitely look because you'll be seeing what's underneath, right? You've already done the homework. You've already understood your client. Remember, you can understand your client better than anybody else. So you already know what's underneath, and you can use what's underneath to actually affirm your client and use that vocabulary in court, and it's going to be really powerful. If they call your client non-compliant and defiant, what possibly could you say? What language could you use to affirm your client? If it's hard, and I'm going to help you again, how about struggling to manage some of our expectations, right? The prosecutor says, like, he's defiant. It's like, well, Your Honor, he struggles to manage some of our expectations. Because if we really think about defiance, right? What is it? It's not following rules. Well, children struggle, right? It's not they just don't want to follow rules. It's there's something happened to them that makes them struggle to follow rules, right? So it's our job to explain that. How about if the child is called disrespectful and oppositional? And I promise every DJJ report will have something about your client being oppositional. What language would you use to change that rhetoric in court? It's hard. Okay, we're gonna make it through. Appears to be frustrated by what is being expected. Right? Wouldn't you call that the frustration can show up as being disrespectful? Right? So try to think about it if you could use that vocabulary instead. Incorrigible, you've seen that before. How would you call a client otherwise than using the word incorrigible? How would you reframe it? Perhaps they require additional support and guidance, right? Of course they do. But just here, you say that. When everybody calls the kid incorrigible, it's such a pejorative word, right? When you say, well, my client requires additional support and guidance, that shifts the burden on us, a society, on guardians, on everybody else takes it away from your client, right? Juvenile offender and delinquent. Well, there is a lot. I know it's a juvenile 101, defense 101, and we still are like struggling to change the vocabulary. But all in all, the word juvenile has been considered to be heavily focused on criminality of a child instead of just a child being a child. So we're trying to use words like youth, or simply using the child's first or preferred name. It's very powerful, right? I would strongly encourage you not to talk about your client as a juvenile. We can use this word, in a generic way when we talk about, Juvenile Defense, Department of Juvenile Justice. There is a juvenile, justice statute and all of this stuff. We cannot always avoid that word, but if we can stop using this word to describe our client per se, especially when they are around and they hear it, I would suggest stop using it altogether. So you then use it in front of them, because it carries certain depiction of criminality there. Dangerous neighborhoods, right? You will often hear the prosecutor says, well, he lives in a dangerous neighborhood. How does the child feel when they hear it, right? Obviously they know it's dangerous, but again, if they hear all those descriptive negative words again and again, they start to think of themselves as that's what they are. They perhaps are dangerous, like if everybody else around them is dangerous. So we have to change that rhetoric to change the mindset for others and for children. How about you could say communities that experience high level of, and then you can name it. Same with poor. How would you feel if people were describing you as poor or your mother as poor? It's offensive. It's heavy. It's hurtful, painful, right? So let's be mindful about this language and replace it with something that again would be uplifting. You could say youth from low income or undeserved family. Okay. Do you have any questions about this, or perhaps any other words that you would like to brainstorm with the group? How you could change those? Are we good? Okay. So Samantha talked about demonstrating trust and overcoming lack of trust. Similarly, for demonstrating understanding, there's some do's and don'ts that may be helpful. So do not take things personally. I said that before. So that's very important, because then you actually lose your own objectivity. But it is good to acknowledge clients' frustration. When you see them acting up in a way that you consider defiant and you're starting to take things personally, how about you just say, well, I hear that you're really frustrated. I see you are uncomfortable here. You are angry about something, right? You acknowledging it helps them relax into that and be like, oh, I don't have to have that, right? I don't have to act that way because they already see me, right? Being seen is a powerful thing, and actually you can definitely use it in your professional life. Do not respond to anger with anger. Well, it should never be a case that an attorney gets angry, right? I unfortunately observed it in court one time when it wasn't anger to anger, but the attorney said the child for incorrigible offense was supposed to go home. That was the recommendation, but the attorney said, well, they were defiant when they were with me in the office, and they wouldn't listen to me and they wouldn't talk to me. So they recommended for the judge to actually lock it up. So that's an example of pretty much you can lose your license if you do that type of behavior. But it's like it really happened because the attorney took things personally. They took it personally that the kid wouldn't talk to them. Well, the kid didn't talk to them most likely because the trauma that they've experienced and were to share about with the attorney was way too much, and they didn't trust the attorney. But the attorney taking things personally can lead to really bad behavior on the part of attorney. So don't ever do that. But yes, demonstrate willingness to work through the behavior. Again, those type of situations will mean that you're going to have to spend much more time with a client. You shouldn't, hopefully you don't have another appointment or court happening or something, so you can actually pay attention and display empathy to the client. And there was one more thing, which was ask more about worries. So ask your client, you know, what worries him and what, you know, where it stems from. So we have like laid out all those rules for you, and perhaps you were taking notes or trying to remember them all. So we'll give you an opportunity right now to actually see if you can recognize some of things that may be going wrong in interviews with clients, and then how you could use the rules we have offered to you to make those situations better. So in a minute, I will ask Lawrence to break you into groups. There will be pairs. So we have Jamie, Roshana, Cable, and Kimberly. So we have 4 people. Perfect. You'll have 2 groups. It's very easy. Until you're broken into groups, if you could please read the interview A. I provided you with 2 interviews, interview A and interview B. So once you are with your partner, you decide who will be the client, who will be the attorney, but don't worry, you'll have interview B so you can switch the roles. So after you're in the groups and you read the interview to each other, actually, you don't have to read the fact that this in advance. You can start working with your partner, but then we'll all come back. So read the interview to each other. You can talk about what went wrong, and then switch the roles and read interview B, and then we will reconvene in a large group and have a discussion about what went wrong and how things should have gone better. So just a second, I'm going to ask Lawrence to break into person. Okay, everybody, are we back? So have you all had a chance to do the interview? Cable, were you in the room with Kimberly?
Yes, yeah, we got
He
joined.
was, I had a call come in the middle of it, so I apologize for the inconvenience for him.
That's
No,
okay.
it's no problem. We discussed it the interviews.
Okay.
Okay, perfect. So let's look at what went wrong. Well, as far as the exercise A, can you all give me some ideas? What do you think went wrong? Was it an ideal interview or not necessarily?
I would say not necessarily.
Okay, why was that? What did the attorney didn't do right? How about that?
Well, he apparently had 5 minutes to get information on the case, and he didn't have any information other than what the client was gonna tell him, apparently. And I guess the initial report, but he just essentially was trying to rush through everything and get information from the client, and then the client didn't really understand, and then they had to go to court. And he also didn't make any contact with the parent to see if the parent would be there or a custodian.
Right. Unfortunately, many things went wrong. Thank you, Cable. Would anybody else would like to tell us which of the methods or techniques we related to you that attorney could have used?
Trying to relate to the client a little bit.
Okay.
The attorney here seemed kind of short and a bit mean, I guess.
Okay. Building trust, right? Rapport. We've listed a couple of them here. Of course, there was an issue of judgmental language. As Cable said, didn't do many things, but yeah, definitely listening to client, responding appropriately, and accommodating for cognitive development and lack of capacity would be great. Okay, Samantha, you want to run for exercise B or?
Yeah. So exercise B, what are some things that went wrong there? Did y'all think the attorney sort of approached the client appropriately from the get-go about the money, about how he and his mom have been getting along?
It sounded like, I mean, it reads like he was trying to gather information as best he could from the client about the situation with the boyfriend, but then it ended terribly.
Yeah, and then when he started off with, well, first of all, about the mom, about the mom when the kid said she's pissed, and he says, well, what have you been doing? Essentially, what have you been doing to make her mad? And then he was like, well, if you didn't take the money, who did? I mean, he was accusing the kid. And of course, if you look a few lines down from the top, he says, she wants her money back, the money that I did not take, you know. And then the lawyer says, well, let's talk about that. Tell me who took the money if you didn't. I mean, he's like he or she's like accusing the kid in and of it, I mean, themselves as well. Anything else that stood out in that interview that, oh, and one thing I want to say is, like Alex said, as far as how we talked about sort of doing these interviews better, I think the attorney certainly could have rephrased the question, you know, well, if you start doing what she tells you to do, she won't be upset anymore. You know, he could have very well said, well, you know, tell me a little bit about that. You know, what's going on between you and mom, you know, rather than the way he came at it. Anything else in that interview? There was a lot in that one. I thought that was a horrible interview. But particularly at the end, Cable, I think you're getting at what I was trying to get at. I don't know if Cable's on right now, but did you guys pick up anything near the end as far as the issues regarding the sexuality, the client's appearance?
Yeah, the attorney was insensitive and judgmental.
Very much so. Right. Right.
Okay. Well,
I
thank
think
you so
those are
much.
two great examples of what not to do.
Yes.
You
Thank
could
you.
learn a lot from those. So.
Do you have any questions about the interview part before we move on? No? Okay, let's take the word code, the code word 1.3. That's Lawrence. Okay, Lawrence. All right. And now let's go through the juvenile court process and dispositional advocacy. So that will be a lot of information, not much discussion here because we just have to go through the statute pretty much and explain everything. But this little graph shows you for the folks that are not familiar with juvenile justice court, just shows you where we are right now. So obviously everything starts with a petition, a complaint in this, you know, in this instance. But disposition is obviously after adjudication take place and perhaps after evaluation, and we'll talk about it as well. Before we do that, we will need 3 volunteers. So it sounds like Cable has volunteered already, and I guess since it's just 3 or 4 of you, we'll ask maybe Jamie and Rashanda for participation.
Yeah, it'll be easy, I promise. Cable, are you there?
Wait for Cable.
Yeah, sorry, I'm here.
Oh, you're fine. All right. So, are you all familiar with the Price is Right game?
Yes.
Okay.
Awesome. Okay, so this will be easy. Fun little game. All right. We're going to use this game as an example of nothing. I'm not gonna. I'm just gonna start it.
I'm not gonna spoil.
Yeah. All right. All right. I'm your host, Samantha Locke, and we're here for The Price is Right. We have 3 contestants. Let's welcome Cable Pogue to the stage. He's our contestant number 1.
Yay.
Yay.
Our contestant number 2 is Jamie Lord. Let's welcome Jamie to the stage. Contestant number 2. And we have our third contestant, Rashana Nero. Let's welcome Rashana to the stage as our third contestant on The Price is Right. Come on down. Okay. Sorry, I'm a little caught up in the game still, in the music. I'm gonna get my head right. All right. So, as y'all know how The Price is Right works, I'll throw out a question or two, and the contestant who gets the answer closest to the right answer is considered the winner. Okay? So, our first question. Starting with Cable, we'll go Cable, Jamie, and then Rashana. What is the average cost of a 1-year stay in a secure juvenile facility in South Carolina? Now, these are the 2020 numbers. We don't have they haven't updated the numbers, so that's why we're using 2020. But if the three of you can guess the amount of money it costs for a youth to stay in a juvenile facility for a year, that includes the clothing, 3 meals a day, intensive security, and a metal cot. How much, Cable, would you guess that it costs the state per year?
I would guess 20,000.
Okay. Jamie.
I would think around 30.
All right, and then Rashana, what would you guess?
25,000.
Okay. The answer is $197,100.
It's more like 217 right now, but we didn't have the official number. Yes.
So this is the modest number. Apparently it's gone up. So yes, over $200,000 that the state is spending to lock our kids up in a juvenile facility for 1 year. Next question. What is the average cost for 1 full year of tuition that includes room and board, fees and fees to attend South Carolina State University, in-state tuition for an entire year? And these are based on the 2022-2023 numbers.
I would say 30,000.
Okay. Jamie?
I would guess around 35.
Okay. And Rashana, what would be your guess?
$28,500.
All right. $30,440,000. So Cable won that one without going over, and the first one, Jamie would have won because she guessed $30,000 and it was 197, well, 217. So Jamie, you're the winner of the first question, and Cable, you're the winner for the second. Great job. Do you have any prizes? Okay.
Do I get a car?
Not this go round.
If it was in person.
So this is to compare. Obviously, I mean, I was absolutely floored when I learned this last year. This is actually really powerful. It's really concerning to me, because what this tells us is that our wonderful state is investing 5 and 6 times the amount to lock up a child at DJJ rather than investing in their education, which of course would give them better chances, better outcomes for the future. So I keep this in mind when y'all go to court. just one of the many reasons why it's so important for us to advocate for children to, you know, not go to DJJ and to use this as arguments against why kids should be. I mean, judges have seriously convinced themselves that DJJ is rehabilitative and that that's in the best interest for a child, and it's absolutely not. And I think if you can get the message across to judges of how much less it would cost to keep that child in the community and invest that money in educating them rather than institutionalizing them, it has much better outcomes for that child. All right, so that leads us into disposition, okay? So what can the court order? Section 6319-1410 of the Juvenile Code lays that out for us. What's one option that you guys can think of? What pops in your head when you think of the options the court has at the disposition stage?
What are different sentences that a child can get?
Probation.
What else?
An evaluation or community evaluation.
Right, that's predisposition, but it's part of sentencing.
Determinate sentence or indeterminate sentence?
Right.
What would be like the best outcome? What do you think?
Dismissal?
Bingo.
Yay.
So, I mean, I think, you know, I don't think this is thought of as an option enough. But 6319-1410 A7, which is my favorite, absolute favorite section of the Juvenile Justice Code, says the family court may dismiss the petition or otherwise terminate its jurisdiction at any time on the motion of either party or its own motion. I have certainly moved for dismissal, probably not enough cases, but hats off to one of our judges in Richland County who I've seen, even without asking, has on her own dismissed cases. And I can really, really appreciate that she's done that. Here we have a quote from Randy Hertz. He's a professor at New York Law School, from the Trial Manual for Defense Attorneys in Juvenile Delinquency Cases. Dismissal should, of course, be the result if it's in the interest of justice or for social reasons.
Mm-hmm. And we actually have a sample motion for you, and then we will put in resources, because I don't know if it was in your case as well, but we've had a couple cases where we have submitted written memorandum in support of the motion for dismissal for social reasons. As you know, the objective of the family court is to rehabilitate a child. So if you have a client, perhaps the case was taking for a long time, and you can demonstrate that the child is rehabilitated or is not even in the need of rehabilitation, then you certainly should be moving for dismissal, and you can use the motion to support your argument.
Yes, absolutely, absolutely. So what are some of the factors that should be considered when moving for dismissal?
This is for dismissal.
The seriousness and circumstances of the crime. Okay, if it's something petty, I mean, let's say shoplifting, and like Alex said, you know, it happened a year ago. I mean, the money's been paid back. I mean, what's the purpose at this point? It serves no rehabilitative purpose whatsoever. That would be a perfect case scenario to move for dismissal. The extensive harm caused by the crime. No harm done. I mean, again, you've got to look at the purpose, the rehabilitative purpose. If you didn't even have anyone that was harmed, I mean, what are you teaching the child, other than for the purpose of just trying to punish them, which is not the purpose of the juvenile justice system. It's about rehabilitation, not punishment. Any exceptionally serious misconduct of law enforcement personnel in the investigation and arrest of the respondent, or the presentment of the petition. I wish I had about 30 minutes to talk about a case I had here in Richland County. But let's just say that my client and all 3 co-defendants, including 1 adult, had their charges dismissed, and the investigator in that case was actually fired. And I was able to build that case from watching body cam very carefully and asking a lot of questions, and connecting dots that clearly were disconnected. So anyway, that's another thing that you can look at. And I will say, just my time in Richland County, I've seen the solicitors dismiss some cases because they, on their own, because they've noticed misconduct by law enforcement. The history, character, and condition of the respondent. Of course, if you have a respondent who's not, I actually have another case scenario. I mean, I really wish I could tell you all about these, but I have another case that a kid had 8 pending charges for some car break-ins. Law enforcement had clearly coerced this girl to say that she'd been breaking in cars with my client. Comes to find out, and that she was carrying his baby, everything. And that was the one time I seriously begged my client to let me try that case, although I knew he wasn't going to get out at that initial detention hearing because he had a long record. And I didn't get him out the first time, but we came back to the 10-day detention hearing. I laid out everything for the judge. The other thing was I left the jail at 6:37 that evening. I'll never forget. And I had over 6 hours worth of body cam to watch, which wasn't going to happen for the next day for the detention hearing. Sort of fast forward, and I went to the 10-day, told the judge all the concerns I had about the truthfulness of the not only law enforcement but the so-called the girl who indicated that she was breaking cards with my client. And the solicitor finally had an interview with her, and she admitted that she lied. She didn't know my client, had never seen him before, certainly wasn't pregnant with his child. So all 8 of his charges were dismissed. But I mean, that was a case I will never forget. But that's something that you have to look at as well. And then the needs and best interests of the respondent. I guess first thing that come to my mind is maybe I've had a lot of cases with incorrigibility or assault and battery where the parent is the victim. And, parents will, go through all of the, talk to the parent. Do you really want to bring charges against your child, et cetera, et cetera. And if I get the parent on board, I've certainly been able to get many cases dismissed where the parent's been a victim because I've gotten them on our side. And then the need for protection of the community. This is a big one. A lot of times, we'll talk about it more as far as even probationary conditions. I think Alex alluded to it. There's really no need for some of the conditions that they place in these probation orders. If it's not a case where there's really a safety issue for the community or the protection of the community, it's not necessary to adjudicate all of these cases or that are going through the court system at all. Any other relevant information that you could find that would serve no useful purpose. Again, the purpose is supposed to be for rehabilitation. If there is no rehabilitative purpose behind that, then move for dismissal. I think it was Kimberly that mentioned probation is another option, obviously. 6319-1410. Probation can last for a kid, as you know, not to exceed their 20th birthday. Home placement or out of home placement might be a condition of probation. maybe not going home right now is not the best option for the child, you know, seeking alternative familial placement, or, you know, anyone else that might be able to take the child. Last option should be DSS, because I'll just leave it there. Yeah, so whether it be home or out, in home or out of home placement, that can be a condition of probation. Probation should not be used as punishment. Again, I've said it, and I'll say it again. It should be used for the well-being of the child and the child's family, not in protection if necessary, but not as punishment. And of course, the conditions must be directed to discovery and correction of the basic causes of maladjustment and development of the child's personality and character, etc. One thing that always annoyed me, and I would say to all the judges, you know, they kept, I remember I had a female client, and the girl kept coming back, and she was 14, and, you know, filed a probation violation. Well, she wasn't going to her counseling. Well, her mom admitted she wasn't taking her to counseling. How is it her? I said, Judge, she's 14. She can't take herself to counseling. Her mom kept putting her out, going back and forth to dad's house. And I remember the judge here, she, you know, knew I was fighting tooth and nail about that girl going alternative placement, because both DJJ and the state were asking for that. And you know, took us back in chambers, and, oh, Miss Love, I know you're not going to be happy with me, you know, but, and I said, you know, this is a temporary, one, it's a temporary solution, right? And two, if you keep locking up a child in alternative placement and not addressing the underlying issues in the home, and keep putting that child back in the same environment that led to them being here in the first place, what are we going to get? This child's coming back. And although the judge acknowledged, surprisingly, that it was a temporary solution, she felt like that's what she had to do. So here, again, I've already alluded to, but here are some conditions of probation that are listed in the statute. A community mentor, monetary restitution, we'll talk about that more in detail in a minute. Supervised community service, employment as a constructive nature, of course, that will help promote rehabilitation, and then a fine. The statute says the judge can award a fine or impose a fine not exceeding $200 when the offense is one in which a magistrate, municipal or circuit judge has the authority to impose a fine. The other thing I want to point out is that a fine may be imposed when commitment is suspended, but not in addition to commitment.
If I can mention something, just to go back to this statute, make sure you pay attention to what's being asked of a child on probation. Again, boilerplates, probationary orders are commonly used, and you definitely need to challenge them based on this statute, right? The statute says condition must be directed to the discovery and correction of the basic causes of maladjustment. And, you know, so make sure it's also tailored to your child. And after you have communicated with your client what is feasible for them to do, right? Let's not put all those things on the kid and then expect them to turn around, because it's oftentimes way too many things that they suddenly need to change. So you have to be able to tailor it to your client's wishes, needs, feasibility, but also per statute, you actually, you know, have to ask for that to be related to underlying offense as well. Kimberly, do you have a question?
I just wanted to also mention, I had an issue that we get the evaluation back, and the evaluator put the recommendations of DJJ in the evaluation. And when I get to court, they're different. The DJJ, local DJJ, want to make them different. When I followed up with that, apparently DJJ, local DJJ, is not supposed to change the recommendations in the evaluation recommendation. So that's something to be careful. So they had one where they wanted my client, they said very short term of probation. And then the local DJJ said they wanted probation for 18 months, which I didn't feel was very short. That's just one area, but they're not supposed to change them unless they have extenuating circumstances, because they have a chance to voice their opinion during the evaluation process. And that what DJJ file puts in the report is supposed to be the DJJ recommendation.
Great point, Kimberly. Thank you.
Another thing I've seen is, DJJ's recommended alcohol and drug treatment. Well, why does my client need to sit at a Loradak for 6 hours a week when they never used any drug or alcohol, and the parent has no suspicion of drug or alcohol use? And I'd ask DJJ, did you ask, why would you recommend that? The parent must have said something. I said, well, you might want to ask again, because they told me that they had no suspicion. So I was able in that case, I can remember the judge didn't order it. Another thing with the counseling, of course, counseling is always ordered as a condition of probation. There was a girl that was out in Lexington who was, I think around 16. She was 16, and she was in DSS custody, I believe. Or was staying in some other out-of-home placement, and it was clear that she and her mom were never living together again. And so I did get the judge there to remove the condition of family counseling. What do you need family counseling for if they're never going to live together again? I mean, it was a waste of time. Neither her nor her mom were interested in going to counseling together. So here, back to restitution. So this is one to pay close attention to. There are 2 state laws dealing with restitution as a condition of probation. One, and I think they're on the next slide, but let me see. One, we have 1725-322B, which specifies the factors the court may take into consideration in determining the method of restitution that the person is ordered to pay. And here we have some of those things listed here. The monetary loss, of course, suffered by the victim. Weighing, consider this amount against the number. I'm sorry, this actually, the statute I just read is the not the juvenile statute. This one here is section 6319-1410A3. And these are the things that the judge should consider when ordering your youth client's amount of restitution: the monetary loss suffered by the victim, the child's role, weigh the amount suffered against the amount of individuals involved, the child's ability to pay over a reasonable period of time. And DJJ is supposed to develop a system for transferring the court order restitution from the child to the victim. So they make their payments to DJJ. DJJ has a some account or something, and they get the monies to the victims. Oh, I also want to mention DJJ has something called earn and return, which is not something that I utilize as much as I think I should have. It was late in the game, I think, until I learned about it, but it's a program there where they can essentially have the kid like do jobs in order to work off their restitution where they're not able to actually pay it. So be sure to ask your probation officers about earn and return if your client's just not able to pay restitution. The other thing I want to point out here is that it's important to stress, I've had to do it in the case. Consider the amount of kids involved in the incident, and just argue against it. I'll just leave it there. I've been successful where the state, even though they knew that there were multiple kids involved, they would seek restitution in full from one client. And I've had the judge in both cases only order my client to pay a third or a fourth, whatever, however many kids there were involved. All right. Here we have, this is back to 1725-322A. So it says, when the defendant is convicted of a crime which has resulted in pecuniary damages or loss to victims, the court must hold a hearing. And we'll get to the next slide unless they agree in open court to the amount. Don't let the state or the judge make you think that your client doesn't have a right to a restitution hearing. They do. And I've unfortunately had to remind judges of that.
Right, myself as well. Judges would deny restitution hearing, and I would file a motion for reconsideration based on the statute. And it is such an important thing. Not paying the restitution on probation is #1 reason for probation violation oftentimes. inheriting cases from other attorneys where a kid pled and was ordered to restitution of $1,000. It's heartbreaking because those kids can never pay it back. So absolutely, that's a very important thing to fight because it has such long-term consequences and very likely will translate into commitment of a child. So be equipped with this, power of the law that says, you have a right to a hearing, and also we will send you sample motions for that hearing, so you can use if needed.
Yes. Okay, so commitment. Commitment is another option. Of course, the court has at disposition. 6319-1410 says commitment must be for an indeterminate sentence not to exceed 22nd birthday, as we know, unless sooner released by the department, or for a determinate commitment sentence not to exceed 90 days. So just to point out that determinate sentences can't be more than 90 days, but that's 90 days per offense that they've been adjudicated for. So you're trying, and I have used this multiple times to try to avoid a child going to alternative placement, or even I've had at least one or two that I can think to avoid indeterminate commitments. Your child has this, multiple serious offenses, getting them, 3 or 4, even 4 90-day commitments is better than an indeterminate sentence, especially if they're like 15 and, probably not going to do too well at BRC, which, no surprise. But yeah, so just remember that the 90-day commitment is 90 days per offense if you need to utilize that. The other thing I'll throw out there is in cable, I'll say in Richland County, if you get a situation like this where a kid is nearing their 18th birthday, use it. I'm like, Your Honor, there is no need to spend state resources sending this child for an evaluation. They'll be 18 in 2 months, 3 months. They won't be able to benefit from the juvenile court system anymore if they get any charges. So I would ask the judge, ask Your Honor for a 90-day determinate sentence. And I will say the judges, for the most part, in Richland are really good about that.
Right. We would actually ask for 30 or 60 days as well.
Yeah.
So it's up to 90 days per charge, but if it's a simple assault,
Yeah.
in the magistrate court, they would get, time served. And I would always bring up the, equivalent of adult
Right.
charges, but you can ask for 30 days as well.
Yeah, and I've done, we've done that too. If you get Gwen Jones, ask for, if y'all are fighting over it, you can just go down and ask for 30, knowing she won't do it because the state's asking for 90, but she'll meet you or 60, she'll meet you in the middle and do 45 stuff. All right, here are some numbers from, again, these numbers just have not been updated by DJJ, but these are the numbers for indeterminate sentences from the 2019-20 year. And what this graph shows is that even though there's been a reduction in the overall commitments percentages, the percentages by race still remain disproportionate in numbers, with no big reduction in racial disparities. So can y'all see this pretty well? Can y'all see what okay.
And that's by circuit, so you have circuit.
Yeah, so if you want to take a look at your circuit, see what's going on there. There you go. Let's see, who's the highest there? Shocking. Richland. I'm shocked. All right, prior to commitment, however, the court, before committing a child as delinquent as part of a sentence, shall order a community evaluation or temporary or MEC evaluation. Okay, that's what the gist of it is. If it's an MEC evaluation at the Midlands Evaluation Center, for those of you who may not be familiar.
Helen is from Charleston, so she would have
Low
country, and then Kimberly would have whole country.
Oh yeah, I'm sorry, I keep forgetting there's CEC and UEC as well. So yes, the local evaluation centers, upstate, low country, and then here locally, 45 days by statute is the most that a child can remain at the evaluation center. So be sure that you hold them to that and don't have your client remain at the evaluation centers longer than 45 days. We've gotten in situations where, oh, it's the holidays. Oh, well, I don't care. Then we've had to do consent orders to release them. They'll come back after Christmas, but they're not staying there longer than 45 days. There are some situations where an evaluation is not required. One, if the child has been previously evaluated and the report is available to the court, that's typically it's within the past year. Typically, if a kid's been evaluated more than a year, I've seen judges the majority of the times go ahead and send them back. Unfortunately, I've seen judges, if it's been a few months short of a year, they'll just send them back again, which is a waste of time. But most of the time, let me just say, okay, because most of the time there hasn't been that much of a change to warrant a child getting reevaluated again. So also, no evaluation is required if the child within the past year has been released for parole from probation and the previous eval is available. That goes along with what I've just said, except that I think that's the parole. Oh, if a child has been released from parole. So that's the difference between 1 and 2. And then 3, if a child receives a determinate commitment for the 90-day determinate, they don't have to have an evaluation done for those sentences. The other thing I'll throw out there that I have used, if a child is pending, has just undergone a pre-waiver evaluation, and the recommendation and likely outcome is going to be an indeterminate commitment, you can waive that evaluation, that additional MEC evaluation, and use the pre-waiver evaluation in lieu of it. You just have to put that on the record, get that in the order. And I've used that twice that I can think of in Richland. It's not beneficial for a kid to go sit at MEC and undergo another evaluation.
Right. If I may just say something about the evaluations, there is a lot of, we will talk about the dangers of detention. The secure evaluation is pretty much incarceration. It's the kids are treated as if they were already committed. They wear jumpsuits. They're often shackled. They pretty much sit in jail for a month or 45 days. The evaluation takes up to 2 days, and the rest they're just being observed, or I call warehoused, because really that's how it feels. By all means, fight against secure evaluation, unless it's very serious violent crime, then it warrants the secured evaluation. Unfortunately, many judges use it as a default mechanism. They just secure evaluation for every case. It should not be that way. There should be a presumption for a community evaluation where a child can go home and receive the evaluation at home. We will also share an article based on the studies done by a child psychologist here in South Carolina, who has looked at the recidivism rates when it comes to children going to secure evaluations. When children that go to secure evaluation, they are low risk and they mingle with kids that are high risk offenders. The recidivism rates actually spikes up incredibly. So I've used it in my advocacy against secure evaluations for judges. And this now paired with DJJ being so understaffed, the conditions being so deplorable, perhaps will give you a winning argument to keep kids in the community. So try that as much as you can.
Yes, thank you. Here we have 63-19-1450, which talks about mental illness in children with intellectual disabilities. And I have to say, I mean, this is just continues to be a huge issue, a huge deficit in the system in our state. It says no juvenile may be committed to DJJ who's seriously handicapped by mental illness or retardation through voluntary admission process or institute the necessary legal action, blah, blah, blah. You can read the rest of the slide. But children who have serious mental illness or intellectual disabilities should not be committed to DJJ. And I have argued until I'm blue in the face, and still yet DJJ is full of children with serious mental illness and intellectual disabilities, and it does absolutely nothing but make the situation worse. But just keep reminding the judges that the statute is there and it should not be happening. Okay, so the maximum commitment of the 90-day commitment sentences, these are under 6319 1440 F. These are when the 90 days are appropriate. If the child's been adjudicated for a status offense, obviously the maximum amount of time they can do for that is 90 days. Number two, the child is held in contempt for a mandatory school attendance order, truancy, or as a result of the adjudication for a status offense. And then three, of course, if they were to get a probation violation where the underlying offense was a status offense, that probation violation also cannot exceed 90 days because the underlying offense was 90 days. Good time credit. All right. So a child is entitled to good time credit for determinate sentences. If they get good behavior, the DJJ unfortunately determines what good behavior is. And if the child has served 2/3 of their sentences. The court, however, can, in its discretion, take away the child's good time credit. I know Alex has seen it happen before. I have been in court where the solicitor has asked that the judge order that the child not get good time credit. Thankfully, I haven't had it happen, but a judge can take away that good time credit. And what that essentially like for, let's say a kid got a 90-day determinate, assuming they get the credit for good time, it's 1/3 off of it. So it's really 60 days they would do of the 90. All right, pre-confinement credit. That's where a child is held in temporary holding in a detention center, one of the detention centers, or during their secure evaluation time, the 45 days. And if they're subsequently committed to DJJ for either a determinate, for an indeterminate sentence or determinate, right? Yeah, a determinate or indeterminate sentence, then they're entitled to pre-confinement credit. That's the amount of time that they were confined, again, in the detention facilities or during the secure evaluation time. Is that clear? That does not include the time that they've gone back to sit at MEC. Let's say they get a 90-day suspended to alternative placement. Well, those up to 90 days that they're sitting and waiting to be placed, they don't get credit for that time.
This
Yeah, go ahead.
This pre-confinement credit does not apply to sentences of 90 days suspended to placement. So it applies to 90-day sentences, determinate sentences, or indeterminate sentences, but not the one that are suspended. So if a child already was confined for 30 days, spent 30 days at secure eval, and then the judge orders 90 days suspended to placement, that the 90 days is not reduced by the prior 60 days in confinement. Just make sure you explain that to the judge, because sometimes it takes some time to find a placement for a child. And that's why you also have to be mindful of what sentences are being considered, because this 90 days suspended to placement could be a really bad sentence. If a child was already confined for a long time, insecure evaluation because they don't get the credit, and then they go to a secure evaluation and wait for up to 90 days for a placement where his or her sentence will start from then. So they can be pretty much a DJJ or locked up for months more than they would have received on determinate sentences.
And two more things I'll note about that is I had a kid one time who got a 90-day suspended alternative placement. DJJ just drug their feet, claiming they couldn't find a placement. and they found one miraculously on day 89. Well, guess what? Those 89 days he got no credit for, and his time didn't start until he went to alternative placement. That's so unfair. And I'll get your question, Monia, but the other point I wanted to make on that, I forgot. So go ahead. What's your question?
I want just to go into detail a little bit more about that. I think what you just, the last thing you said cleared it up, but they could be sentenced to 90 days, suspended on a placement, they're being held waiting for the placement up to, on 89 day, then go to the placement, and then none of that time would applies to the getting their time in placement.
Absolutely.
That's correct, because the time and placement is determined by guidelines of their charges. So they can get a guideline 3 to 6 months. And then placement, not only do they have to meet the minimum guidelines, and again, the time does not count, but they have to meet certain requirements of a placement. Each placement has their own point system, or whatever behavioral incentive point system that they create. So children not only have to meet their guidelines, but they have to be on good behavior to actually reach a certain threshold for being released. And again, none of the 89 days counts towards that. So be very mindful of it. Mm-hmm.
But from reading this slide, if they spent their time, they had already spent 89 days. Any pre-determination time, if they were on an indeterminate sentence, would get credit.
Yes. Also, if they were on determinate sentence but not suspended to placement. So let's say they got 2 charges, and you argued that they get 180 days, 90 days for each charge, and they have 75 days or whatever, how many days pre-confinement credit, that would count. So it counts in determinate sentences or indeterminate sentences. It does not count when the 90 days is suspended to placement.
The difference is that they have that 90 days suspended.
Yes.
That's when it will not count, which brought me, reminded me of my other thought, the other thought I had. I think Richland County has it in their order for like 45 or 60 days, but I learned from that experience to always ask the judge for a review hearing if placement is not found. And I would ask for 45. I would even try for 30 days, but the judge typically would give them more time than that. But ask for a review hearing. Don't let the kids sit there for 90 days, because DJJ will take their time sometimes in finding placement. But at least if you come back, you have a review hearing in place, then that gives them a push to be looking for placement before that review hearing. Okay. And let's see. So, it's just a few. We'll finish. Okay. Earn compliance credit. So DJJ may grant up to 10 days of good credit or earn compliance credit when a child is placed on probation. Or as part of their parole order. So I would always explain to my clients that, if they get 6 months probation, then as long as they get their earned compliance credit, they are going to get 60 days off of that. So just remember that it's 10 days, up to 10 days for every 30 days. The other thing I wanted to mention about that is that a kid can lose their credit for 1 month, but not another month. Let's say they get a graduated sanction, month 2 of probation, but then they've done well, they get back on track month 3, 4, 5, and 6. They will pick back up on their credit. It's not like an all or nothing sort of thing for these purposes. That gives your client, I use that as like, sort of encouragement to do well on probation. Because listen, hey, even though you're hearing 6 months, you can be done with it as little as 4 months, and they always like hearing that. All right, so here we narrow down, okay, who determines release time for indeterminately committed juveniles? DJJ determines release for status offenses or and I know this isn't right, this is just what the statute says. It says, or misdemeanors other than ab hands or ab wicks. Well, yeah, this is from the old law before those statutes were changed. Those are not misdemeanor offenses now. Or violation of probation for status offenses or misdemeanors. So DJJ would determine release time for those offenses. For any other offenses, it would be the juvenile parole board who would determine release. And if you ever have questions about release guidelines, I generally would like to go straight to I didn't prefer to use the local offices. So I would contact either Tracy Washington, if it was alternative placement, or Tony Van Loo. They're both at DJJ, and she's the director who deals with the kids who are serving indeterminate sentences. And they can give you the guidelines for how long a kid has.
So yes, let me just say a couple things about the guidelines, because it's really, remember about the ethics rules that we discussed when you have to explain all the plea ramifications, right, to a client. So if you tell the client you're going to go to alternative placement and you don't know for how long the child goes, how could you possibly explain the ramification, right? The same with indeterminate sentence. Obviously, indeterminate sentence is until they are 22. But that doesn't mean they will be there necessarily until 22. You have to understand what happens when the child actually is sentenced, right? So that indeterminate sentence. So the guidelines for all alternative placement and indeterminate sentence are different. That's why you have to contact different people. There is a grid that you can fill in and actually figure it out yourself what the guidelines are, but you have to have a very correct history of your child's prior criminal history. And I would not rely on that because you can actually make some errors. You have to know 100% what it will be so you can properly advise your client. So contact Tracy for alternative placement. Those guidelines for placement are always shorter. Like on UCP, it would be 3 to 6. Whereas if a child has indeterminate sentence on unlawful cargo of pistol, it would be much longer guidelines. So don't think you can just use one number from this to put to another. So figure out the guidelines and explain to the child. In alternative placement, the guidelines work different because at the minimum guidelines, as long as they have been behaving well and reach all these levels that the placement requires of them, they will be released. Indeterminate sentence, obviously a whole different species because they have to go either in front of DJJ release authority, like Samantha was saying, if it's misdemeanor or status offense, which is a better, more liberal, I would say, authority system. They release kids much more frequently and easily than the parole board. Parole board is very conservative, and it's really hard for kids to get paroled, especially on serious charges. So acquainting yourself with the parole system, I think, is really important because, again, you're able to better explain your client what they are facing while they're at DJJ. But when they go for parole when they reach the minimum guidelines, that does not mean they will be released. Okay, most likely they won't be released. There is presumption against release prior to the guidelines. And even at the guidelines, they have to have recommendations from their ISO, from the social worker at DJJ, and from education. So they really have to do an awesome job to be released. So again, there's no guarantees whatsoever, but the more you know about the system, again, you're better explain to them. And you have to tell them, which is true, that they may actually be never released until they're turned 22. So you have to give them all those facts, right? And that's the fact. Many kids on especially murder charges, serious charges, are not released by the parole board until they turn 22 and jurisdiction expires. So again, be truthful, be correct, accurate, and make sure the kids have an idea of what they're facing so they're not superbly caught by surprise. Do you have questions about any of that? we're finishing the sentencing portion of the presentation. We're going to have lunch break. But do you have questions when it comes to whatever Samantha or I were saying so far?
Yes,
No?
can you explain? I keep hearing status offense. Can you explain? I'm sure I should know already. What is a status offense?
Okay, so status offenses are offenses that only a child can be charged with. So anybody under 18, an adult could not be charged with those offenses. They include incorrigibility, so being beyond parental control. So obviously you cannot be charged with incorrigibility, but like, you know, your children, if you have any, could be. Truancy, so not going to school and missing school days, and runaway. So if you leave home without permission and you're gone. So those are status offenses, and status offenses, unfortunately, in South Carolina, children can be locked up for status offenses, as Samantha was saying, up to 90 days. Those are very problematic charges to deal with, like more difficult oftentimes than like criminal charges, because there is all this gray area and this home environment, family situation that you have to go into. So they can be very complicated. And again, locking kids out for status offense makes absolutely no sense, because it doesn't fix any of what's underlying, what's happening. So yes, it's a great problem in South Carolina. We are one of the few states in the United States that actually violate a federal law that says that children cannot be locked up for status offenders, because we continue to incarcerate kids for status offenses. Does it answer your question, Manya?
Yes.
Okay, awesome. Anybody else? We're good. Okay, well, stretch out, go for a run, walk, jog. Have something great to eat. We will see you in 30 minutes, okay? And we'll finish up strong, okay? Thank you.
Hey, is
Go ahead.
is it possible that you guys could tell us what the best resources are, books and such, reference books are, before the end of the presentation around juvenile practice in South Carolina?
Yes, yes. We will not only tell you, but we will include it on the CCID website, and we can also email it.
It's a great binder that I use, I've always used, and you can actually use print it. It's about 90 or so pages. You can print it from the website, so we'll
include that for sure.
Thank you.
You're welcome. I'll put it in the chat as well. Okay, so let's see who is with us. Jamie Rashana is here. We have a few more people possibly joining us for some parts, but okay. Take the code word 1.4, and let's focus now on preparation for sentencing. So we call it predisposition preparation. We will talk about theory of disposition, developmental framework, and then whom we have to engage to prepare for disposition. So as Samantha before was referring to the In Re Gold case, In Re Gold, which is really a classic case that established a representation for youth, says that the child requires the guiding hand of a counsel at every step. So just like we were saying before, we are in the role of an advisor, and we really have a duty to advise a client about so many different things, and pretty much be that guiding hand for the child throughout the whole process. So disposition, what is disposition? Disposition is really telling a client's story, right? We all have a story to tell. We pretty much are born into the life like, you know, as a blank page, and then leave life as a book. So, you know, we accumulate all those chapters of our story. And story is like, it's like a narrative thread of our experiences. It's not literally what happened, but what we make out of what happens, right? and what we tell each other and what we remember of what happens. So what that provides, it provides context for a client for what happened, but context equals compassion. So it's really important to contextualize everything. So our clients are perceived as real people, and then we can focus, we can, help other people understand the aspects of our clients that go beyond the offense. So now we will do a little short exercise about how we can tell stories and put things into perspective and in context. So it's really important to think about who the client is and how did the client get here, and then create the theory of disposition. So just remember that your client is not just the act that he or she is adjudicated for, but they are a complex series of experiences, strength, and possibilities. It's really important to emphasize that it's not the young people that we represent. Those are people that really can, in many ways, contribute to the society if they're provided that opportunity and are supported. And society misses out as a whole if the clients are not part of the community. So, I mean, you're the only one that's with us so far, unless somebody else going to pop up. Hello, Cable. So good, we have 2 willing participants. If anybody else wants to join, we'll be having a little exercise right now on telling stories. So as you can see, you see 4 pictures, pictures that you can possibly see as part of your discovery, or perhaps a prosecutor would present those pictures during the disposition hearing for your client. So let's look at the top left, where we see the girl standing alone. And imagine prosecution is presenting this picture on behalf of your client to the judge. And obviously the prosecution will focus on the worst type of reading of the picture, right? So how would the prosecutor interpret or present your client in this picture? Can you give me some ideas? What would they say to the judge? What does the picture depict?
They could potentially say that it depicts her working as a prostitute.
Yeah, I think
waiting on someone.
Sure. Honestly, it probably comes to all of our minds, right? So that's like the most immediate interpretation. Assuming you've already talked to your client and you have some other defense theory here, right? Give me some ideas what perhaps the girl could be doing other than prostituting herself, waiting for her clients, that you can tell the judge about.
She could be waiting on a friend. It's looks like a well-lit walkway that's open to the public. She's just has a right to be there, and she's waiting on someone.
Excellent. Okay, that's the same what you just said. It's just she looks a little differently, right? But yes, excellent. Contextualize it, put it in, provide more information that will definitely shed more positive light on your client. What about the top right, the group of boys in hoodies? Jamie, you want to take a shot at that and tell me how the prosecution would depict this situation for your client, who is one of the boys here? What are they doing in their mind?
The prosecutor would probably try to say that they are sitting around and probably partaking in illegal activities or getting into trouble or trying to do something sketchy, when you could just say that they're all friends hanging out together. They were, in a public place just trying to kill some time or enjoy each other's company and not do anything weird.
Excellent, thank you. Yes, they could be, for all we know, putting together some move dances or songs, lyrics, creating art, right? Yes, excellent. What about the bottom left cable?
I'm sure that the prosecution would say that these are people involved in a riot potentially. And you could, I mean, as a defense, it could be they're running away from some kind of danger instead of running towards it.
Yes, excellent. I mean, I think here if there is a suggestion that the client is practicing for a race, but maybe far-fetched. What about the last one, Jamie?
So they're gonna say that he's like making graffiti, I guess that's the right term.
Yeah.
And like painting on walls that he shouldn't be. I don't particularly know like what a good argument would be to get out of that, honestly.
Cable, you have an idea?
Well, I know that it's pretty popular right now as murals on abandoned buildings or, you know, places like that. It's a beautification of the area. You could be, you know, a really skilled artist.
Absolutely. Excellent. Okay, great. Thank you both for the participation. So yes, that's how we get to theory of disposition, right? We have to tell our client's story, and we have to say that, you know, they're more than the act that they have been accused of or adjudicated for. So let me just ask you, no, I'm not gonna ask you because it's just pointing fingers too much. But like if you look back at your young ages, right? We all have done something that perhaps was not in compliance with rules or perhaps even illegal, right? I mean, yeah, making graffiti painting, or you know, having some issues with a drug here or there, stealing something from Walmart. I mean, as adolescents, we all have had those type of situations that we were just not caught for. So the same, and now, yes, and now we are people that are professionals and they have accomplished something because we were not caught, right? Because we were not caught in a system, because we were not you know, processed through the system and get all the disadvantages along the way. So we really believe that, you know, our youth needs to be depicted the same way, that our society is losing pretty much when they are locking up youth. Not only the money, as you've seen from the beginning, it costs extremely high dollars to lock the kids, but also, you know, those are children with talents and gifts that, you know, our society would definitely benefit from if they were in the society and can be supported along the way. So again, we are the ones who have to pick up on this when you're talking with your clients. You know, tap into their talents, not the typical one, I want to play basketball and, you know, go to military, which is the most common answer, but, you know, dig a little deeper and find, you know, what they're passionate about, and then make sure you tie it to, you know, your disposition theory when you're arguing in front of a judge. Of course, it's extremely important to involve other folks before the hearing, the disposition hearing. A lot can be accomplished behind the door, behind the court door, pretty much. Talking with DJJ intake officers or probation officers, negotiating with them. You know, they will be providing the recommendations to the court, which is like a, you know, starting point for the judge. And if the starting point is, you know, something you really don't want, you should probably invest a lot of time to work with DJJ behind the court doors. The prosecutor as well, I'm sure you all negotiate charges with and deals with prosecutors. So, you know, develop a relationship that will be of benefit to your client, but also get in touch with community partners, mentors, and therapists. Make sure you have a whole array of folks that will come to the table, whether it's directly in court or through affidavits and letters of characters and letter of support for your client, so you can argue for the best outcome. And of course, parents are crucial. Oftentimes at the beginning, at the detention, stage of the offense, you're gonna have a very frustrated parent who is done with their kid, right? They're done. They want them locked up. They want them to learn a lesson. So that's the toughest one. But hopefully, after the time in detention or after certain time passes, the parent is already, it becomes more of an ally for the client and for your case. So you have to, again, always, as we were saying at the beginning, represent a youth and their express interest. But to have a parent that's fully opposed of your child coming home, your client coming home, will be really difficult in the end. So you need to work with the parent. And if you can, you have a social worker table in your office, and hopefully others will have similar supports. From the day you actually get assigned to the case, you should be looking into what's going on in the house and what support system the parents need. Your social worker can be working with a parent on the support system while you're working with a client on the legal case, right? And whatever needs the child has. Because the more supported parents are, the more, they really are dealing with a lot. So there's no blaming them that they sometimes don't want the kid back home. But, ultimately, I believe everybody wants their child home. It's just they're overwhelmed. So if you all can find ways to support the parent as much as you're supporting the client, that would be great. Again, utilizing social workers it's a great idea in this case. And then make sure you gather all together support. For disposition, you can prepare a disposition package. Like, it really depends on the severity of the case and, obviously your time management, how much time you have on the case, but you shouldn't shy away from using definitely letters of support. You could be community partners, church members, mentors, people in the neighborhood, but letters of support are very helpful if those people cannot come to court. If they can come to court and testify, if you have a mentor that you can bring to court, it will really mean a lot. And I will say the obvious, but male mentors are really welcome in court, because the judges are so rarely see a male figure for our clients that, when they see a man coming to court to support the child in whatever ways, that usually goes a long way. But obviously that shouldn't be that you're just looking for male mentors. But I've just seen an extreme positive response from judges when you have those people in court. Look at school records and, see what you can find as mitigation from school records. Oftentimes kids will have IEP records or 504, and perhaps you can find some arguments there that support your theory of disposition. See if you can, get any awards or certificate that the child has received so far to add to your package. If a child has been at DJJ, at MEC or something, oftentimes they will be able to get something there. But if you need, I would definitely, advise for you to have mitigation witness. Obviously, you have to secure funds for that, but in serious cases, when like the child faces indeterminate sentences, it would be a really great investment to have mitigation witnesses. Those mitigation witnesses sometimes work with the victims, sometimes just do all these things that, we're suggesting you to do. But if you have a lot going on, perhaps a mitigation witness can do it for you. So yes, you can create a package, disposition package. You can just put it all in your oral arguments. But the more you have ready in advance, the better. Definitely look at the school component. If the child's school was disrupted, how will they go back to school, right? What is the process going to look like? Have you already, you as an attorney, figure out, what are the steps for the child to take to go back to school? Because the school component is so crucial that if you have it already figured out, that will convince the judge more likely to allow the kid to return back to the community. And then definitely be aware of the direct and collateral consequences of criminal adjudication. this is something you also have to advise your client of. So you have to be aware of the child is facing in order for them to understand it as well. So of course, the most direct consequences would be that school is notified, that they, for certain offenses, they will get a DNA swab. Driving license can be suspended. And most serious one that you have to be really, really aware of and advise your client about is the sex offender registry. So as you most likely know, the law has changed recently slightly to give a possibility of the being taken off the registry, at least in theory. I don't think in practice it will work that well, but this consequence is pretty much a lifetime consequence, and it's of such significance that I believe, yeah, attorneys should be disbarred if they don't inform the clients of the real consequences of sex offender registry, because it's of such importance that it really causes the full disruption of the child's life for life. So be very well acquainted with those consequences. And then we have collateral consequences. So there's tons of things that can happen because a child was adjudicated. Housing can be disrupted if they're living at, Section 8 or some other government housing. If a landlord finds out that there's been some adjudication of a child, they can evict the whole family. Of course, school disruption. It could impact adoption, employment, financial aid, college admission, and of course, military. So I actually was oftentimes asked for a waiver because my client would eventually apply for military, but they were adjudicated delinquent of some serious charges. Those waivers are obtainable, so it's not a full prohibition that they will not be allowed into military, but they have to go through a waiver process. So for you, we're not going to talk about each of them in detail, but I would encourage you to click on this link. I mean, you can click, we're going to put the link in the chat. Or go on the SCCID website. We actually have 2 booklets on collateral consequences. One like a version for adults, pretty much. This one is more of a version for young people. You have to acquaint yourself with that, and you have to explain it to your clients. If you would like, I can mail you the hard copies. I have several boxes of this little booklet, so you are welcome to grab them. Do you have any questions about the disposition or theory of disposition? No? Okay, perfect. So we are now into exercise 2. No, it's like 4 or 5. So it's the fact pattern 2 that I have sent to you. So if you could please pull it up if you don't have it printed. It's the one about Janet Ford. So we will spend a few minutes to actually read it just in case you haven't had time before. So let's dedicate like good 5 minutes to read it. And then next slide. Here are the questions. So while you're reading it, please think about those questions. Do you think DJJ will recommend secure evaluation? Do you think the judge will order that Janet will be sent to DJJ for an evaluation? And then we have more discussion questions. So take a minute. Maybe I'll give you like 7 minutes so you can also maybe jot down the answers. So when we get back, you can, yeah, you can be ready. 10 minutes. 10 minutes? Okay, so I'll give you 10 minutes. Samantha is definitely advocating for you to have 10 minutes. So 1:18 we'll be back. Hopefully you have, yeah, we'll be back. Okay, so let's talk about Janet. And it would be awesome if we can all talk, because it only makes sense if we do the trainings for you to actually put it into work. Otherwise, the information will be gone, right? So the more we practice right now, the better you're gonna retain it better. So what do you think? Do you think DJJ will recommend secure evaluation for Janet? Okay, but what do you think?
Well, I believe the judge could order a secure evaluation. I would argue against it because she's already on probation, and if she's allowed to return home and continue on probation while the case is pending, then she would be supervised, so she could have a community evaluation.
Okay, so let's actually go into more even factors. What factors can be considered in deciding between a secure evaluation and CE? So you definitely meant supervision, right? You mentioned that. What other factors do you think the judge would weigh for and against when it comes to sending her to secure eval?
The nature of the crime.
The nature of the crime. So what is the crime?
Receiving stolen goods and unlawful carry of a pistol because it was underneath the passenger seat where she was sitting.
Okay, so based on the nature of the crime itself, on the offenses, do you all think it would be a secure evaluation determination? It's a gun charge, right? How do our judges react to gun charges? Right, Jamie's shaking her head. Is like, yeah, not great, right? So even if the gun wasn't used, right, that's usually a big alert for a judge that the child was even in the presence of a gun, or definitely if they plead guilty to UCP, that's actually means that they were in possession of the gun. So that's not in favor of community evaluation. What other factors would the judge consider? You know, what other things the judge needs to look at?
Her history.
Okay, excellent. Her
And
history. Mhm.
her prior criminal record. It's not extensive by any means. So if she were released home in a detention hearing, then I would argue that she could have a community evaluation because she doesn't have an extensive criminal history.
Yes, 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 yes. That's very good. Other factors that are being considered for secure evaluation?
Would her school history of attending go into that evaluation, or would that be more of like a probation issue?
So it's a great question because unfortunately, I would say judges look at school attendance, and use it against kids because their argument will be like, oh, you're going to have school in a DJJ if you're not don't go to school in the community. So yes, the school attendance and school performance plays a big role. So here, if we have all the absence and stuff, again, judges oftentimes would say, you don't feel like going to school at home, you're going to be going to school at DJJ. That is, so how would we rebut that argument if you were to defend Janet and the judge would be so honed on the school attendance? How would you, find some other arguments to rebut it, contextualize it? Do we know why she was missing school?
Could you talk about like the mother's issues and mental health, if that would play into why she's not getting to school?
Yes. So what do you all think about this? Because all of those arguments are, yeah, we're going in the right direction. There's always this little, the area of cautiousness. You have to kind of weigh between, okay, if we want her to go back to the mothers, we cannot, we have to put the mother in a light that would be also favorable, right? So if there is a history of not going to school and we sort of blame it on the mother, then the judge will say what will change, right? So can we work with this a little bit more? If we say yes, it's she had mental health issues and the home situation wasn't stable and mother wasn't stable, what do we do to convince the judge that it will be different this time? What could we possibly do?
I would say potentially having the mother made a party to the case. I mean, she could, she would be responsible for making sure that she gets to school and goes to school. And that could give her some kind of motivation, the mother, to comply
Sure.
with that.
Definitely. And then maybe what we were also saying a little earlier about giving mom support, right? Perhaps mother struggles with her own things that, if we can find support for that. I don't know, Jamie and Roshana, if you were on when we were talking about the social worker. Richland County has a social worker in juvenile cases. And I was encouraging Cable to make sure that, you know, the parents get the support. And obviously, if you have a social worker in the office, it's much easier for you to focus on the client's case when the social worker focuses on the guardians. But it's still possible to interview the parent and kind of see, you know, where the struggles come from, and perhaps, you know, of some resources for a parent that, you know, will equip the parent with just, you know, being more stable. And you can also bring it to court and say, look, judge, this is already in place, or we're making a referral, or, you know, there's some other support that the parent is receiving. So again, always be cautious about, you know, how you present what happened, so then the judge does not feel like, okay, if that's such a bad situation, I will never send the child back to the bad situation. So we have to address the underlying reasons, causes, or factors to the extent possible. Or otherwise, you know, judges will hesitate. So, okay.
Oh, one thing on that, I'll just add. One important thing is just to know your judges. Because anybody will tell you, I'll be the first one to throw a parent under the bus if it means saving my client. I'll throw anybody under the bus. DJJ, you can ask them. And so, but I'm only bringing this up because, like Alex said, though, that could go both ways. So I'm careful about it depending on who my judge is, right? If I'm in front of certain judges, I know they're not going to hold this child responsible. And I say, Your Honor, I would ask that you stress to this parent that she's a party to this order. She's obligated to ensure my client gets to school, gets to her appointments, et cetera, and I'm thankfully never had it backfire, but it's just because I had to learn, you know, I had to learn the judges first, right? So it's not going to always work, but it'll work with the right judge. The other thing I was going to say, well, we probably just haven't gotten there yet, so I'll just wait on that. So that's what I want to add about that one.
Okay, thank you.
Would you be able to use to go toward her missing school as far as like her grades and maybe her not understanding at the level that she's supposed to be?
That's where I was going.
Yes, absolutely.
Yeah.
Go ahead. We can elaborate on that.
Right. So, you clearly Janet's having some issues, right? And like you said, maybe she's not going to school because she's not understanding. She failed the competency standard test back in the 6th grade, 8th grade. Now she's in the 9th grade for the second time. Clearly, there's some issues in school that have not been addressed, and so she needs to undergo, what's called a psychoeducational evaluation to see if she needs some additional services in school, perhaps in what's called an IEP, an individualized, individualized educational plan, to see what supports, academic and or otherwise, that she might need to help her succeed in school. Perfect. Absolutely where I would have gone with that. I have a background in education. I thought when I left education law that I wouldn't have to deal with it again, but yeah, you do, you know, when you're representing kids, but it does come in handy so many times. I've been able to look in an IEP, see if it appears that the school has been doing what they're supposed to do, see if, you know, academically, behaviorally, where the child is, are they getting the right supports? If not, you know, then the team needs to get back to the table to see what that child needs to succeed, because clearly there is a pattern there. In addition, it mentioned that she has attention issues with staying on track or with attention, so perhaps she has ADHD. So that's a big issue that definitely could resolve or at least help improve the school issue. That's great.
Right. So, okay, that's very helpful. One more factor that's always considered in deciding between a secure evaluation and community is the risk of flight. All right. So, in fact, the judges should always list the factors when they're making determination for a secure evaluation. So if it's not done, then it's not done appropriately. But the judge should consider risk of flight as one of the factors. And I hardly ever have a client that doesn't show up back to court or is the runaways kids maybe, but you can address it through like ankle monitor and this type of thing. So Janet's risk of flight is probably not too high, right? So she should have a chances of getting the community evaluation. But what factors and issues will be of concern for the PO, the prosecutor, and the court? So we're going to the next question. What factors and issues will be of concern to the probation officer first? What do you all think? Has she been complying on her probation?
It says she's been like mostly compliant, just some issues with curfew, but she has skipped some of her recent appointments. But the main issue probably they would focus on is how she didn't sign up for the program that probation needed her to sign up for.
Yes, yes. And what could be a possible explanation for that?
Mom didn't sign her up.
Right. Samantha really loves parents.
Yeah. And I'll say it, so, and this is talking about this, of course, DJJ is like, oh, she didn't sign up for the program. She's already been on probation for months. Well, in a case like this, I would definitely, I'm gonna look at the order, see what all she was ordered to do, and see what DJJ hasn't done yet. Because I promise you, 4 months has passed, and DJJ probably hadn't done anything. My most popular question when a kid's on probation: how many times have you seen your probation officer? What's your probation officer's name? Man, I can't remember that. Okay, that's the problem, right? So I go to court and I'm like, Your Honor, my client's been on probation 4 months. DJJ hadn't done this, DJJ hadn't done that. So my client shouldn't be held responsible for what DJJ hasn't done. She can't go to counseling when counseling the referral hasn't been made, right? She's having these issues in school. DJJ hasn't tried to bring it to mom's attention or, to anybody's attention. So again, I mean, I always try to get not that obviously, I mean, that's my job though. Was my job to take the blame off the child, not to say that, they can't be held responsible, but at the end of the day, they're kids. And I always try to remind the courts and everybody else, when I was 14, 15, or 16, I mean, I wasn't able to do the things that I guess seemingly they expect kids to do. And I would always tell judges, we can't hold kids more responsible than we do parents, right? They're adults, not these kids. And so let's look at why this child is, we're in this situation and see what can be done by the people who owe these kids a responsibility, because they cannot be held responsible. There was a judge in Lexington who used to always say, oh, well, Ms. Luck, it's time for your client to grow up and be a man. And I'm like, well, Your Honor, he's 12. So he's a ways from that. It's not going to happen right now. So, again, it goes back to the whole concept of treating children like children, right? So sorry, I told you I'll go off on a tangent.
It's okay. When it comes to, just on the same tangent, when it comes to the probation violation and things like this, I would request the DJJ record of file pretty much of what they've done. And that's how the probation violation would usually be dismissed, because they know that they haven't done what they need to do, just like Samantha was saying. Okay, perfect. So that's the concern of the PO, because she's been on probation, all this. Prosecutor in the court, what else do you think they could bring up against Janet? What their concerns would be? We talk about the gun, right? Gun is always a concern, even if it hasn't been used. And some judges take it very personally, especially if they are the one who places kids on probation. They just think, magic happens, and then suddenly kids supposed to abide by all the rules, and they should listen, right, to the court order because the judge ordered that, so the kid's supposed to do that. So if there is any other rule violation or new offense after the kid already should have known, that could become really problematic because judges again take it very personally. Okay, anything else that comes to your mind? Okay, so what disposition options are available to the court for this offense? Can she be incarcerated for this offense? So other than evaluation, let's say we dealt with the evaluation already. This is when it comes to the disposition options, Samantha related all of those options to us. What do you think can happen for this type of offense in this case? I think Cable already recommended her to continue on probation, right? So you, Cable, have already suggested one disposition option. But what other options do you think are pretty much viable here?
Like the judge could sentence her to a suspended sentence with alternative placement. That could certainly happen.
Yes.
She could get a determinate sentence, but I think it would either be an extended probation or a suspended sentence with an alternative placement.
Yes, very likely. Do you think indeterminate sentence is a possibility here at all?
Based on her, she has a prior petty theft and a marijuana charge that she went through diversion for. So it would be unlikely, at least in my opinion, for her to get an indeterminate sentence, but it's possible.
Yes. I agree with you wholeheartedly. Very, very likely she would not, but she can get indeterminate sentence. So the part of the question is also, can she be incarcerated? Well, in our state, yes, because she can actually get the 90 days suspended to placement. So that's an incarceration, right? There's 90 days she spends in a secure evaluation facility. And placement is also incarceration. Or she can get a pure determinate sentence. Can Janet legally be ordered to pay restitution? What do you think? So there was a damage to the car, right?
I would say yes, that she could be ordered to pay restitution.
Were there other people that were caught?
I think she was the only one that was apprehended.
Right. You're right, Cable. Unfortunately, she can be ordered restitution. If they're asking for $3,500 and Janet, no way, will have this money in the next 12, 18 months, what are you asking the court to do? There's a disagreement. Prosecution says 3,500 and you don't want 3,500 for her. What are you asking for?
That she be responsible for a fraction of of the amount based on however many people are in the vehicle.
Sure. And even less than that, like just take her age into consideration, right? What is really a reasonable amount of money she can possibly earn in, while she needs to focus on school, improving her grades. If she, she has all these struggles at school, I would definitely argue that that has to be her priority, not the restitution. So perhaps just a nominal amount of restitution, or even community service hours. Sometimes judges really are keen on ordering community service hours instead of restitution. Those are the cases where we should be looking at like the least amount possible that the child can pay. And again, it's not the parent responsibility, it's the, the ability of a child to make this money. And I think in this case, she needs to focus on school. Okay.
But be sure and get the paperwork before you agree to any restitution to make sure insurance didn't cover that and they weren't asking for the deductible back, because I've had that happen.
Right. So oftentimes it's nice to, even at the disposition, we just put it in abeyance, that restitution issue, or schedule it for a restitution hearing when all the paperwork comes back. Don't ever agree to anything until the paperwork is back and you can confirm all these facts. Usually the more you put this in abeyance, they go away. Those things go away. So don't hesitate to do that. And do you try to get Janet to admit more knowledge or responsibility or give up her friend? And if so, what does this conversation look like? What would you say? Have you ever had a client that be like, I'm not a snitch, and they take on some serious charges? Even in an adult court, right? So it's not just kids. But this no snitching culture can be pretty detrimental to clients, because again, they don't understand the consequences of some of the charges. So what do you think? Would you actually try to get her to admit knowledge, responsibility, or actually give up her friend? What would be your strategy here?
I think there's a good way that you can try to get her to understand the part she played in it by also try to make her understand the part that her friends played in it, and that it's hard to be in that position as a kid, but just like she has to take some sort of responsibility, so should they, and just see how it kind of resonates with her. I saw in Lexington a judge give an indeterminate sentence to a kid who just refused to give up the people that also were involved, and it was a heartbreaking situation to see. And it was just really unfair that he basically took the brunt of all of it just because he thought he was doing the right thing at his age to not give them up. So it's really heartbreaking to see that happened to a kid.
Absolutely. And I think I know which judge you're talking about.
Your heart will continue to be broken as long as you're there.
Right. So no, it's terrible. And again, the kids don't. So yes, you're an advisor. You need to definitely take some serious time and explain to the child what the consequences are. Another thing is, like in other trainings, we teach you a lot about adolescent brain development and the theories of disposition that you could use for that. Like children are really susceptible to peer pressure, right? Definitely Janet's case here. But if we have nothing to say about the other co-defendants or people that were involved, then we can't really even follow this theory. So perhaps Janet needs to understand that it would be extremely helpful for her case to both take responsibility, but also for us to be able to talk about the other peers involved. Okay, do you have any questions about this exercise? I really wanted you to, so you brought up something, Jamie, you brought up one, case, but do you have any other examples that, come to your mind right now as something striking, something you have questions about, or perhaps you have your own case that you are working on and we all could brainstorm about some theory of disposition? Just take a minute and think about, and we'll talk about it. Even could be a short one, it could be more complicated, but we would like to be able to brainstorm something with you.
So Jamie, you are handling juvenile cases there?
No, I just follow Catherine all the time, and so because I really like going to juvenile court, but I see a lot and it's really, really sad. There's just something I feel really bad about for these kids, and you guys know the judges there, and I mean, you bring a marijuana case in front of them and they act like it's the end of the world. I mean, it's very hard to see.
Yeah, a runaway is detained, they're going to NBC, they're not going home. I mean, it's extremely, it's they're way too conservative. I don't think they still don't understand the repercussions, even after all the fussing and crying I did.
I Catherine does a great job too.
Cable, any like, since you're in juvenile court regularly, any like recurring issues that you're seeing or like with your cases or challenges that you've had so far?
I guess
Figuring out which way.
in general, there's issues usually, well, a lot of detentions that are occurring in Richland County and related to a lot of gun charges. And so that's been the majority of what's happening in the past month or so. And then on the other end, it's usually for the cases where it's an incorrigible or runaway. Oftentimes, it seems like there's some kind of issue at home, or pretty much always there's some issue at home that's resulted in the child's behavior.
Right. Are y'all handling the truancy? Well, are you handling truancy cases?
No.
So detentions, do you usually have children plead guilty at the detention? Either immediate one or the 48 hours?
It just depends on the circumstances and reviewing the discovery and meeting with the client.
Okay.
The good thing, I unless something's changed in the last couple of months, the good thing in Richmond County is, they see so many guns, they don't act like somebody's dead, as they would in Lexington County if a gun charge came. It's just like, oh, Jesus is coming back. But the benefit of that, I hate to say this, but the benefit of it in Richland County is that the kids typically, if it's their first offense, they typically are being placed on probation, right, Cable?
Yeah, typically, if they don't have a record, it's usually a probation sentence.
The only issue is I noticed before I left, the gun on school charges. Yeah, that they stopped like consenting to release on those charges, and so even though the kids typically are being released, especially if it's their first offense, they'll at least go on the record because I guess the solicitor's office doesn't want to be the one to say, oh, well, we agreed to release this kid after they took a gun to school.
Okay. So no, you don't have like a disposition case that you'd like to brainstorm, Cable? I mean, I'm not putting you on the spot, but you're like the one who has cases, juvenile cases.
Nothing on the top of my head right now.
Okay.
Okay. Everyone wants to come back now. We'll get started on the last section, Cable's favorite, detention hearing. All right. So here's a roadmap of where we're going next with detention hearings. We'll talk about probable cause hearings, go over the dangers of detention, eligibility for detention, coming up with a release plan, talk about some of the statutory and developmental constitutional considerations regarding detention hearings, and then use of racial and ethnic disparity data at detention hearings and why that matters. Okay. All right. So here are some stats from 2018-19 regarding race and the amount of youth that were detained in that year at DJJ. Here you see it was 3,503 youth. A huge percentage of those detained were Black youth, which I'm sure is no surprise to anyone. And then the white youth in the gold, and then other youth of other races in the brown area. All right, so first of all, here are some of the most common detention offenses. I want to know, hear from you guys I don't know if Cable, you may be the only one who knows. These are some of the typical detention offenses for which kids are detained statewide. just across the state. Cable or anyone else, do you see this? Do you see anything different in your counties? I know you already mentioned the gun charges.
There's been a breaking into vehicles has been one. If there's multiple cars, multiple vehicles that they've broken into, typically they'll be detained.
Okay. So here we have, motor vehicle larceny, grand larceny was one that I saw a lot here too. A and B third, which is, I think it's just ridiculous. Runaway, again, ridiculous. Probation violation for misdemeanor offenses is a common detention offense. Possession of a weapon, of course, contempt of court, probation violation for felony offenses, unlawful carrying, and probation violation for status offenses. One thing I know they used to do a lot or they do in Richland County is if a child is, this isn't really, well, it's still being detained, but if a child is like out on a community evaluation or suspended or one suspended to an MEC evaluation, they've done a lot of, they'll do contempt of court and detain a kid. But I will say, I would be able to typically get the contempt charge dismissed. If they want, typically the solicitors would be willing to dismiss the contempt charge and just sort of deal with the underlying charge. Okay. Now we're talking about probable cause hearings, right? So the judicial determination of probable cause required, the state bears the burden, of course, and this is equivalent to preliminary hearings in adult court, right? And so the state must has the burden of proving that emergency one, or that there were, I'm sorry, this slide is not done very well. And that's my fault, probably because I didn't pick up on it. Let me back up. So I think let me skip ahead first. It's going to make a little more sense. So when a kid is detained, there are certain timelines that they have to be in court. If it's a status offense, a child is detained, they are supposed to be in court or released within 24 hours. Okay. If it's for a regular criminal offense, let's say the child is not already on probation, so it's not a probation violation filed, it's just a regular offense. Let's say they're discharged, with detained for having a gun at school. That child has to be in court within 48 business hours. Now, that's different for the status offense statute, correct? Because yes. So that for the status offense, the statute just says 24 hours.
Doesn't exclude weekends.
Does not exclude weekends. I will tell you in practice, nobody seems to worry about following that. But for any other offense is 48 business hours. So if a kid, let's say in this example, was detained on a Saturday, the time doesn't start until, I don't know why the time really doesn't start until Monday. We have it on Tuesday.
Well, because it's the closest one.
So technically, honestly, this hearing would happen on, I guess we would do it on Tuesday in Richland County, but I think probably some counties, if they want to just stretch it out, they probably have really until Wednesday to have it in, because the kid got detained on the weekend, so that time is not technically counting towards the statutory limitation. Within 72 hours, if it's a violation of a court order, so a kid is out on probation, DJJ filed a probation violation, they have to go to court within 72 business hours. And again, I know in Richland, nobody's gonna let a kid sit there from Saturday until Thursday. So, I mean, we would have had that detention hearing, honestly, probably on Tuesday, if we were prepared to go forward. So I'm gonna back up to this case, the County of Riverside versus McLaughlin. And our juvenile statute 6319-830A. The state bears the burden of proving emergency or other extraordinary circumstances to justify delay. That's why I wanted to go forward first and come back. So I know that there's been an issue in Richland County. I don't know what other issues there are in other counties about regarding the same issue. But so when judges when they have like chambers weeks or they're at a conference, we don't have like detention hearings every day. And so that results in kids being detained longer than they're supposed to be. And before I left Richland County, not long before, thankfully, one of my clients' parents were related to someone in the legislature. And they didn't understand why their 15-year-old was going to be sitting there for like over the weekend and not going to court until Wednesday. And of course, I was like, yeah, that's against the statute. Like the statute said your child's supposed to be in court, but the judges have a conference. And so anyway, the judges were contacted by someone and the solicitor's office, and so that kid did get to the court. But it's a shame that you have to go those extremes just for people to follow the law. But that's what happens in practice. I will say, the one thing I will say about Lexington County is they were really good. I don't know what they do now as far as like if judges are at a conference or something, but they were really good. We were stickler about getting kids in court timely. And it wasn't just me, the judges also questioned if they thought it was delayed. They wanted to know, why is the kid not going to court? So that's the one thing I did appreciate. Okay. Yes. So we talked earlier about status offenders and the fact that federal law prohibits detention of status offenders, which I guess South Carolina just doesn't care about federal law. But here we have reference to the JJRA, which is the Juvenile Justice Reform Act, which was signed into law back in 2018. And then it was amended in, there was an amendment made that's called the Juvenile Justice Delinquency Prevention. And it dealt with the issue of status offenders, detaining status offenders, and how long they were in detention facilities. And so the issue here was that the act prohibited children or prohibits children from being placed in a secure detention facility or a correctional facility if they're charged with an offense that would not be a crime for an adult. And of course, that's the way I typically define status offenses, or explain them, I should say. It's not a crime for an adult. It's only because you're a child. It also focuses on alternatives to detention for status offenders. Alex, do you know if there's any county that actually does? Well, that actually prohibits detaining status offenders?
Well, no, because our law contradicts the federal law. So, so the Department of Public Safety, because they monitor all jails for compliance, because we have to report to the government, the compliance with this law. And we're not in compliance, but they only play a role of collecting data from the jails. But because our statute, as we were saying earlier, allows for 90 days incarceration of status offenders, we're not compliant with the JJRA. I would still encourage you greatly to bring it up. Most of the judges have no idea about the law. But you know, it's again, we're not in compliance with the federal law. So what happens? We lose funding from the government for grants, and whatever funding we get, we have to use on the institutionalization of status offenders. So there are programs that are being put together to make some changes, but it's really moving slowly.
So there's an exception to the JJRA, which is known as the valid court order, violation of valid court order, which means that if a judge issues an order with conditions that's attached to a status offense, right? Then the judge can, it does allow for detention of a status offender only if the court issues a written order that contains this specific information. One, the court has to identify the order, the specific court order, that's the VCO, the valid court order that's been violated. They have to specify the factual basis for determining that there's reasonable cause to believe that the status offender has violated the order. They also have to include findings of fact to support a determination that there is no appropriate, less restrictive alternative. And the biggest part of it is that the court must specify the length of time. It's not supposed to exceed 7 days. And the order cannot be renewed or extended, and the court should not issue a second or subsequent order. So again, I hope someday we get in compliance with the federal law. That's something that's always really annoyed me. And I'll say, and like I mean, I'm sure, Jamie, if you haven't already seen it, you'll see in Lexington County, they detain a ton of status offenders. And like I said, typically they're unfortunately sent to MEC after being detained. In Richland County, they claim they don't detain status offenders, but what they'll do is they'll just conveniently throw in another charge with it that's not a status offense. So, oh, well, throw in an A and B third in addition to the runaway or resisting arrest or something like that to justify detention.
Again, I would definitely always quote this law or cite this law in your advocacy, and just elevate the standard. It's our statute. So there is a pending law that was also called Juvenile Justice Reform Act of South Carolina. So that law actually reforms the offenders related statute and actually mirrors the federal law. We'll see how far we're gonna go next year with the law, but with the bill. But yeah, quote the federal law and elevate the standard for status offenders for sure. Do you have questions about the JJOA or valid court order? Okay.
All right, so challenging probable cause. I used to avoid detention, having testimony at detention hearings all the time because I was like, oh no, I don't. They were like scary, but then.
That's what I wanted to ask you, Cable. Like, do you actually argue probable cause at the detention hearing?
I haven't had that many so far, but sometimes I believe they do argue the probable cause, but usually it's held in abeyance, and you argue the matter of detention. And that's if you have an idea if the solicitor and DJJ are going to pursue detention. Usually it's a matter of seeing if the parent shows up to take custody of the child.
Okay. This probable cause pretty much just like preliminary hearings, right? You were saying that is a big matter in and of itself. When I started practicing many years ago, I was never taught to challenge probable cause. It was just like, well, probable cause was this, and you move on to the detention factors. But if you think about it, probable cause is it's like the basis, right, of a case. The case may actually fall apart if there's no probable cause. So it's crucial that we pay attention to the probable cause really carefully.
And when I wanted to go back a minute. I wanted to mention, there's two basic purposes of detention hearings. One, obviously, to determine whether or not there was probable cause, because if there was not, the child has to be released. Even if there was probable cause, does the child need to be detained pending trial or other disposition of the case? As Cable mentioned, so sometimes I've definitely always had full detention hearings on the more serious charges. Less serious if need be, of course. But the issue that we would run into is that we didn't have discovery most of the time, at least not an adequate amount of it, or not as much as I wanted for the initial detention hearing. So in those cases, I would perhaps argue detention, hold probable cause in abeyance until the next hearing. Unfortunately, the kids got detained here, like on a murder, attempted murder. They typically, they're not going to be let out anyway. So, but just keep in mind that it serves two purposes having that detention hearing. It's not only whether or not the child should have been detained to begin with, but even if there was probable cause, is there a necessity to keep that child detained? All right, so for probable cause to exist, there must be a reasonable belief that the offense was committed by the suspect, right? It has to be reviewed objectively by the court and must be more than a mere suspicion. And this is language from Beck versus Ohio and Illinois versus Gates. I will say that what's always been really difficult or challenging is that I've never seen a judge in my whole 5.5 years of doing juvenile defense. I've never seen a judge agree that it wasn't probable cause. Even when I can tell you one case off the top of my head because it's fresh, that there was not probable cause, and the judge still found that it was probable cause because of the charge in and of itself. And so it's just, have you ever had a judge find no probable cause?
Once, like literally once, but I would still say, there are other reasons to argue probable cause, because you can definitely use, what you find out for cross-examination later, and it's definitely, but one time.
Yeah. So like Alex pointed out, yes, you can, Mike Matheson, who used to be in here in Richland County, he would have detention hearings all the time, just so just wanted to get information. And it was a good strategy. So but yeah. But like I said, the point of this I wanted to point out is that unfortunately the probable cause, the standard is very low. So most of the time, unfortunately, the judges will find that there was probable cause to detain the child. All right, here we'll go over some of the arguments against probable cause. You got to look at, do the facts of the alleged offense establish all the elements, right? So anytime, especially when I started out, I would just constantly look at the statute and look at every single element and make sure that the elements were met. Prime example, they used to charge kids a lot with possession of a stolen vehicle. And I remember a case, the child ended up pleading to, I think, unlawful use, because I'm like, well, he didn't know. He didn't know the car was stolen. He says he didn't know. You can't prove he knew it. So he's not pleading to that, right? Or if you've got 5 kids in the car, the ones in the back seat is charged with possession of a stolen vehicle. Well, they weren't possessing the car. They're riding it. They can't drive the car from the back seat, right? And so I will say I saw a switch in that once we were arguing those actual elements. So you have to pay attention to what the elements of the offense is, and make sure that all of those are met. You also got to look at, do the facts support the belief that your client did it? So just because they're with some other kids and a crime was committed, it doesn't mean your client is the one that did it. So they need to establish that, right? And if they can't, then challenge probable cause. You also need to look at, are the facts alleged based on reliable information? As I stated earlier, you might have an issue with witness credibility. Was there a witness supposedly, that was named an incident report? Now they're not able to be, they want nothing to do with it. They're refusing to come to court or testify or give any information. Well, okay, then how are you going to establish probable cause, right? So those are some of the arguments you can use to challenge probable cause and detention for your kid. All right, can you call defense witnesses and cross-examine state's witnesses? So here are the rules that apply regarding detention hearing or probable cause hearings. Rule 31 of the says that the judge may order detention of a child in excess of 48 hours upon adequate evidence and testimony. You absolutely can, you can cross-examine the state's witness, which is typically the officer or investigator involved in the offense. You always have a right to cross-examine them. The other rules that apply are 6319. I'm sorry, I've already said it. Sorry, you guys, my throat is hurting. Hold on 1 second. Okay. Let's see. So 6319-830A also requires DJJ to submit a report to the court containing the facts and circumstances around the case and make recommendations. DJJ, so I don't think in Lexington County, they gave DJJ a copy of, at least back then, I don't think they gave DJJ a copy of the discovery. I know they do here. And I don't like the fact that they do that, because DJJ will make recommendations to the court based on what they've seen in the report. And oftentimes what's in the report may not even be correct, right? They don't have all the facts, and yet they're making recommendations to the court about your child, about your kid, when the facts aren't correct. So that's been an issue. I mean, that's an issue. I don't like that, but it does happen. Again, you do have a right to cross-examination, and your client, of course, obviously has a right to due process for probable cause hearings. So here are some tips for cross-examination at probable cause hearings. At one, I've already talked about, know the elements. 2, anticipate defenses. 3, start with the source of information. Lock in witness testimony. So I talked earlier actually about holding off on probable cause hearings until the 10-day detention hearing so that I could have more discovery in the more serious charges. One of my colleagues, she would sometimes do the opposite of that, because before the officers can, sort of change what they're claiming, she would go ahead and have the detention hearing so that she can lock them into their testimony. And so and then if there's something comes back later that contradicts the testimony, then she could use that. So it definitely goes both ways, and can be beneficial to go ahead and do that cross-examination at the initial detention hearing. Be precise and detailed. Don't forget closeout questions. You don't want to leave anything obviously unanswered or up for interpretation, or for the judge to just fill in the blanks, because I promise you it's probably not going to be in favor of your client. Don't confuse your client with the suspect or assailant. Back to what Alex mentioned earlier on, even about referring to your clients as juvenile, I always just refer to my clients by their name. I would never call my client a juvenile like in court or I always refer to them as their names, so they can be, they're people, right? And so we want to present them as people. Don't ask the ultimate question, even if you think you know the answer to it. And the last one I have on here is to build one fact at a time, no compound questions, which is something I had to actually learn to do. But again, the more you do detention hearings, the more comfortable you get with them, and they can really be beneficial. I didn't like to have them in cases where I knew, like, the facts were just really bad. So especially if you know that the judge is likely not to let your child out because the charges are really serious, then it might be beneficial just to hold it in advance. The last thing I'll say before I pass it back on to Alex is I never waive a detention hearing. It's one thing to put in an order that I'll hold in advance, and I might hold it in advance for 6 months, but I'm not waiving it. So if I want to come back in 6 months and have that detention hearing, I always have that right to do that, but I will not waive a detention hearing.
With probable cause hearing?
I'm sorry. Yeah, probable cause hearing. Yeah.
Don't waive detention hearing without consulting with your client either.
Oh, yes.
Right.
Right.
Because that happens sometimes.
Yeah. So next, Alice I think is going to finish it up. Just sort of still talking about detention hearings and some of the things you want to consider, and we will touch on the issue of race in this section as well.
Yes. So we mentioned race as a factor at the beginning and then later on, and how our state has, this awful statistics with incarcerating Black people more than, or Black youth more than white. So we want to talk about it a little bit more in this section because it has something to do with probable cause and may actually help you with developing your probable cause questions. So we'll talk about reasonable articulable suspicion for stop and frisk. And as you know, reasonable articulable suspicion is closely related to probable cause. Probable cause is more of a higher standard, whereas the reasonable articulable suspicion is a lower standard. But reasonable articulable suspicion is the belief by a reasonable person that the suspect violated law or some rules. And this standard is very subjective, right? So there is really no gray line between what a reasonable person would or would not find to be evidence of a crime. And to meet this standard, law enforcement officers must articulate the facts that they believe show a suspect has committed a crime. The thing is that I want to ask you a question about what are the factors that support reasonable articulable suspicion and probable cause? What are the most common ones that you have heard? Like high crime area, right? That would be one. Do you have any other ideas that come to your mind? What do you commonly hear from cops as basis for probable cause or reasonable articulable suspicion?
Maybe the kids seem nervous.
Right. I'll give you, I'll list them here. Flying, right, or leaving the scene. Samantha said nervousness, casing, description match, exchanges between individuals, gunshots, bulge in clothing, body language consistent with a weapon possession or observation of a weapon. So now, if you take a minute to look at all the factors here, which of these factors are closely related with race? so closely that are pretty much synonymous with race. Take a minute and think about that. Okay, but what comes to your mind?
Well, definitely a high crime area. The departure upon seeing police, furtive gestures, nervousness, exchanges between individuals, those come up a lot. Association with known offender.
Absolutely. Excellent. Okay, excellent. So let's break down some of those proxies for race and talk about them in more detail. So high crime area. There is actually there are cases that you could use in now discussing that because our job is pretty much to disrupt that implicit thinking, right? We talk about it's a subjective thinking of a law enforcement, what that probable cause constitutes. So it is definitely implicit racial bias plays a great role, and our job is to disrupt that implicit thinking and call attention to the ways in which each of these factors have really become another way of tying race to the presumption of criminality, right? So here are two cases that you can use for the argument that your client is a suspect because they were in a high crime area. One is Brown versus Texas, which says that presence in a high crime neighborhood alone is a fact too generic and susceptible to innocent explanation to satisfy reasonable suspicion inquiry. And the same with US versus Montero Camarago, it is that just is because it's a high crime area, because such a description, unless properly limited and factually based, can easily serve as a proxy for race and ethnicity. I would definitely encourage you to pay attention to this language so you can use it in your own advocacy during PC. Association with known offenders, that was also mentioned. Again, there's some helpful cases. This one is Ybarra versus Illinois, where mere association with a known criminal on its own cannot be a basis for a reasonable suspicion. And then in Cibron versus New York, the court noted that reasonable suspicion required more than mere association with known criminals or addicts. So you have a couple cases here. And again, this is just an underlying factors, the ones that Cable pretty much mentioned, and some other ones that point to this correlation between race and those factors. And again, it comes from, it's a very subjective determination, and that decision as to whether nervousness stems from being, engaged in criminal activity, or just because you're Black and you're just scared of cops because they can shoot you, is very much subjective. So this is really worth bringing it up and challenging that. So it's time for our code word, and that will be our last code word for today, which is code word 1.6. It's Cherokee. Okay, so take note of the last code word, 1.6 Cherokee, and then we will go to challenging detention. So as Samantha was saying, a detention hearing consists of two prongs. One is the probable cause prong that she discussed, and the other one would be the detention in of itself, why the child should not remain in detention. So dangers of detentions. That's my question for you. What are the dangers of detentions that you know of? What arguments could you use in court against detention? generally speaking, not only for your particular client, but generally for youth? What does incarceration of children does to children? Okay, so great. So if you don't know, that's even better because we'll tell you, and then you will know. So there is a great study. It's called Dangers of Detention, the Impact of Incarcerating Youth in Detention and Other Secured Facilities by Barry Holman and Jason Zeidberg. And they list several of those factors. First and foremost, high recidivism rate. So 70% youth in detention re-arrests soon after. So it actually contributes to recidivism rates. Detention disrupts natural aging out process. Again, something that you will learn in other trainings, if you continue coming to those trainings, is that we often study or learn about a study that's called Pathway to Desistance, which talks about the fact that children grow out of committing crimes. It's just a natural aging out process. And if we incarcerate them, and especially for a prolonged time, it disrupts that natural process because it puts them in touch with, they just become, they're so disrupted in so many ways that they lose hope, and then they end up in this cycle of criminal behavior for much longer. It definitely exacerbates mental health issues. So your clients most likely, upon coming to detention for the first time, have already been traumatized in some way or another in their lives, or have a high score for adverse childhood experiences. But when they're incarcerated, when they're isolated from their community, when they're actually kept in isolation, oftentimes in this very unfriendly or pretty much inhumane conditions, that really contributes to their increase in their mental health issues, increase in their trauma and depression, anxiety. Actually, children end up having post-traumatic stress disorders, even if they didn't have those when they before they became detained. So that's definitely a big problem. And then schooling is insufficient and disrupted. I would definitely hone on the school as much as you can, because judges usually pay attention to the fact that the kids receive school. So use that as the argument that in Albanese Glen or JDC, the school they receive is so substandard. They're all put together in one classroom, and they get the same information. And they hardly ever receive it. So it's like, it's not on a daily basis. If your child has an IEP, that's definitely doesn't meet, the school doesn't meet the adequate education standard that's required by federal law. And then even if they receive some type of school and they get a portion of a credit, it's almost impossible for that credit to be transferred into anything meaningful towards their high school credits. So they lose seat time, and that pretty much contributes to their dropping out from schools and not getting high school diplomas. I think that's a very strong argument that continuity of schooling is disrupted. And it really, children get victimized at detention centers. There is, in our DJJ facilities, in our local detention facilities, there is officers on youth crime, high number, there is youth on youth crime, there's all type of victimization, physical victimization, and of course mental victimization. And again, the separation from adults and caring adults and nurturing adults is definitely traumatizing for them. So use those factors as much as possible, explore them, and fiercely advocate against detention for your clients. Eligibility for detention. So as young as 11-year-old can be detained. Detention hearings are within, as Samantha was saying, 24 hours for status offenders, 48, 72 hours for regular crimes, and then probation officers. And then we have a statute here listed that shows all the criteria for detention. Look at the statute very carefully. And sometimes law enforcement detains a child on non-violent offense, or it does not, there's no weapon involved, or there's no prior record, there's no pending case, and they end up being detained. So you can request dismissal immediately. Preparing for the hearing, again, Cable, you were saying you have way too many of those, or at least in Richland County. So it is hard, but I would definitely encourage you to involve your social worker in those alternative plans, because while you're working again on the legal aspect of the case, your social worker can be helping you with the home environment and the other aspect of the case, because you have to have some type of alternative plan, whether it's the family of origin or whether it's extended family. Definitely have something in place for the judge. If you can get documents, if it's not at the first hearing, definitely at the second hearing, supported documents like letters of character, have witnesses come to court as well. And then two big factors that are being considered by the judge is whether the child or community needs to be protected, and then risk of flight or prior failure to appear. So here you see what the judge is looking at for the first one. It's of course the offense, the prior history, home, school circumstances, the offense, the circumstances surrounding the offense. And for the risk of flight, what is the history of compliance, and whether the home is stable, and whether there are other mitigating factors for failure to appear. And your release plans, right? Always have a release plan as an alternative. Ankle monitor is usually utilized. Don't ever let DJJ get away with them saying they don't have ankle monitors available, because even if it's not available in this county, it will be available in another county, and they have to secure that monitor. Okay, so don't rely on your county DJJ telling you stuff like that. So you can always contact the state DJJ to confirm the information. What else? You can, even on regular, normally for detention, the child is assigned an intake officer from DJJ that it's not that they don't provide for intensive supervision. If a case is like really difficult for you to advocate for kid to come home, you can suggest that an ISO, intensive supervision officer from DJJ would be assigned to the case. And they can be ordered to meet with the child very often. Like ISOs are usually the parole officers, or on some serious cases. So even on a detention case, you can request an ISO to be assigned to the kid, so they can be monitored much more closely. The judge can order them to see a kid once a week for what it's worth. Obviously discuss it with your client and say, would you be okay with that? Yeah, see if in the community, are there any structures, supervised activities, consider curfew, and mentoring program. Again, all of those things that go into a release plan have to be discussed with the client, because you cannot ask for something that they haven't agreed to, pretty much.
If I can for a minute, add something in there, house arrest. So, in Lexington County, what they tended in their orders to, if a child was placed on house arrest, it also included language that the child was on house arrest unless they were, at school, church, DJJ, legal appointments, medical appointments, whatever, or under the supervision of their parent or an adult of their parent's approval. And then I came to Richland and they're like, nope, house arrest means house arrest. And I'm like, well, hold on. So if the parent goes to the grocery store literally the kid can't go to the grocery store? And they're like, that's the judge's intention. So I'm just like, well, this is ridiculous. And so I had to start sort of a case by case basis asking for, you know, deviations from that. I actually had a judge. I was actually surprised the judge that did it, but she wouldn't even let the kid. He was on house arrest. She wouldn't let him go. It was around Christmas was going to be coming up, and the mom was like, "Well, we always go to my sister's house for family for Christmas dinner." And we contacted the judge, and she was like, "No, house arrest. He's not going anywhere." And I'm like, "Okay, that's not right." But so if a kid obviously has a job, I've never had a judge say they can't work. Unfortunately, I've had judges stop the kid from playing sport, which is really unfortunate because that's something that's a positive thing for kids, right? Just be mindful of exactly what language is going in the orders when it comes to house arrest. Because I also had an issue with the child, what led to the child being detained was he was left home and he by himself. His mom was at work, and he ended up leaving the house and got a gun or something. And he's like 13, and the mom was like, "I can't leave him unsupervised," which is the other issue that the order also says the child's got to be supervised by the parent at all times. Well, that's a contradiction, right? How can the parent supervise the child at all times when the child's not allowed to go to the grocery store with the parent? So it sounds minor, but it became an issue when I was in Richland that I had to start addressing. They got relaxed about it, so okay, but hopefully it's still this way. But they started putting language in there that the child was on house arrest unless they were supervised by their parent or another adult. Is how they started doing it. So just wanted to point that out because that's oftentimes a condition of release as well.
Yeah, that's a great idea. Yeah, make sure you read the order. And again, they oftentimes use boilerplate language, which can be very tricky. So yes, read the order before it's signed, and make sure all the conditions that are listed are something that your client understands.
Jamie, if you do handle family court, the judges there started requiring that I signed off on the order, initially order, before they would sign it. So the solicitor had initial and I had initial that I've actually reviewed it because I was finding issues with them after the fact. I'm like, that's not what the judge ordered. So that I do like that they started doing that.
Okay. Okay, we just talked about this. There you go. It shouldn't be that, you know, one language applies to all. It should be really specific to the client, to the charge, to the situation. Something child already does well should not be in the court order. Exactly, like school attendance. Why are those court orders saying they have to attend school? If this is something that has never been an issue for your client, that should not be part of the court order. Just remember, the more supervision the child has, the more likely the child will be violated for something. Another thing I really wanted to bring up, I think here, which also applies to the secure evaluation, sometimes judges give suspended sentences, like community evaluation suspended to secure evaluation if they violate the court order. And the violation is often left to DJJ discretion. That's an absolute no-no. That's a violation of the child's due process, right? If they are not brought to court for the independent judiciary to determine whether they have in fact violated the court order. All this thing about DJJ pick them up from home because they believe they violated something and put them, you know, in a secure facility is absolutely a violation of your client's due process, right? So make sure you challenge that when the judge, you know, orders the suspended secure evaluation, or in this case, it would be suspended house arrest, right? Release home but that is suspended on being picked up to detention center if they violate one of the conditions. Again, it's way too much discretion in the hands of DJJ, and way too much subject to their subjective determination of what the violation is. So always make sure your client has a hearing.
Or, I mean, just along those same lines, even if it doesn't say, give discretion to DJJ, which I think ultimately is going to be the thing. But just to say that if the child violates, they're to be taken immediately to MEC. And I'm like, no, they're not. That's a violation of due process. They're entitled to a hearing. And then it's the judge, because I have had an issue several times that kids have been violated, detained, and I've been able, there's been some mitigation that I've been able to come up with and the judge like release that kid back. So yeah, definitely make sure you come to court first. The only time I've always made sure that they didn't put that in an order. I have had situations where kids have been detained, unfortunately, for obvious violations, like they were on house arrest, but they went to the fair and then ran away again for 2 days with the kid they weren't supposed to have contact with. And so then here we have a contempt, like another charge, right? And so I have only after speaking to my client first to see if they would agree, got them to agree to just go to MEC in exchange for the contempt and any new charges being dismissed. And thankfully the solicitor here, they've been willing to do that.
Okay. So just in case you don't know how to contact your client, and because contact information for DJJ changes on a daily basis, here is an updated way of contact information for JDC, for Albanese Glen, and then Charleston Detention Center. And you will have copies of the slides, so don't worry about it. The same with evaluation centers. Those contact information changes all the time, but this will be provided to you. And clients at BRC. Again, feel free to reach out. We have many more trainings. We'll have next one in the spring. It will be in person. And then we have usually in the summer. And then we have PDA conference. And then a couple other webinars or like roundtables along the year. So yes, it's many more opportunities to meet and talk and everything. Jamie, if you want, yes, Samantha suggested it's actually through the Children Law Center, a juvenile listserv. So where you can kind of connect with all the peers that do juvenile representation. So if you're interested, if you can send me an email, then I will connect you with the right person at the Children Law Center.